Mic test. All right, good morning and welcome back to docket number 24-1004. Any administrative matters before we begin?
Yes, just briefly, just want to enter my appearance for purposes of the hearing. Robert Hum on behalf of the United Illuminating Company, and Mr. Vaughn has some additional procedural.
Thank you. And we did file Attorney Hum's appearance on April 24th.
Right.
Before we begin, we had two procedural questions.
Okay.
I wanted to gauge the bench to see if we anticipated moving from the revenue requirements panel straight to capital if we did this afternoon. I understand from what Attorney Wheel mentioned earlier in the week that Mr. DeFever is unavailable until tomorrow. And so I see we have 5.5 hours of cross slated for the revenue requirements panel, but I was trying to gauge if we would be anticipating starting capital on Friday or going into capital and then returning to Mr. DeFever after capital had concluded.
Thank you for the question. I think given how we are proceeding so far, that we will wrap today after the revenue requirements panel.
Thank you. Thank you very much for confirming that. And a second point is based on those current estimates, we have 5.5 hours for revenue requirement and 5 hours estimated for the capital panel. Would we anticipate beginning the environment or holding the environmental panel until Monday? I think that capital may be slated to end in like the 4 p.m. hour tomorrow if cross estimates hold true. One of the company's environmental witnesses has to travel from Rochester, and that's quite a drive. So if we could get any clarity on that, that would be very much appreciated.
Sure. I think that's appropriate, especially since it doesn't seem we would be able to complete it in one day. So we can hold environmental remediation on page 14 of the agenda. We will aim to begin first thing on Monday.
Thank you very much. I don't believe we have any of the read-ins, so we'll check back in maybe after lunch on that. That's all the administrative matters that the company has. Thank you.
Thank you. Anything from any other party?
Madam Chair.
Okay.
Madam Chair, and everyone here, I've been a little under the weather this week. I have been watching the show. They've been very entertaining. You guys are going to do very well in the sweeps weeks. And I just want to apologize in advance for any noises and emanations that are coming from this side of the bench for the rest of the day. All right, so fairly warned.
Thank you, Commissioner Karen. All right. If there's nothing further, we will resume cross by the EOE, please.
Thank you.
Eric Beckstein.
Am I on? Oh, okay. Thank you. Just continuing from where we left off. Again, my name is Eric Beckenstein with EOE. I had just introduced or referred rather to EOE 263 Attachment 1, and I had cited the $19,000 associated with ASC and the $4,000 associated with AMC. And we were asking, how does the interrogatory 263 Attachment 1 support a finding that these charges represent incremental costs applicable to this particular December 23rd flooding event? And just to clarify, we're looking for actual supporting documents to demonstrate specific storm remediation services performed and any incremental costs incurred. We're not just looking for an explanation. Additionally, since there was an agreement for a late file, we'd like to request similar support for $10,000 costs provided in response to EOE 255 Attachment 1, which is very similar.
We will provide that, Attorney Beckenstein, and I just want to reiterate these storm events. We're using the resources we have at our disposal. Some are fully UI, some are come from our Avangrid management company, some come from our Avangrid service company, but we typically and often do use them in response to these major events. So we'll provide clarity on what those expenses were and why they were applicable to those storm events.
Great, thanks.
Sorry, and just to be clear, if you could just that would all be part of LFE 39.
Correct.
Okay.
Thank you for that clarification.
Okay, moving on, I'd like to clarify the protocol for timesheets in connection with events, including particularly Storm Izzy and Storm Blizzard. So if you could please just refer to the response to EOE 257, including redacted attachment 1. That's page 462 of 508. I was also looking at EOE 165, confidential attachment 1.
Okay.
Okay, I just want to first note, in addition to EOE 165, some of the records referenced in the following questions bear on confidential material. The questions will not directly include or reference that material. So if we could refer to 257, EOE 257, attachment 1, page 462, provides instructions for the timesheet fields. The instructions in box 6, that means the on-site start time, and box 7, which says on-site end time, are described as self-explanatory. But going through this, we notice the instructions for box 25, namely travel time, provide travel time for mobilization, to work reporting location, to work location, and demobilization. Can you just explain, please, whether box 25 relates to boxes 6 and 7 and how so?
So stepping back a bit on the timesheets, and I think I want to frame this in the context of what we're doing in a major storm event. And I'll go back to July when we had a tornado, come through our territory. We mobilize the crews. So if we're bringing in external crews, we will mobilize them and they will show up at a reporting location near our offices. So we are fully aware of when they show up. At that point, we dispatch them with crew leadership from our organization to, number one, to keep them safe. So to direct their switching, to direct them to work. And they are moving at a pace to restore customers. We're approaching June 6th. Dwight D. Eisenhower has a quote that in battle, planning is essential, but plans are worthless. And what that means is that when you're in a situation like that, your people in the field are making decisions and moving in real time. The level of granularity and administrative requirements on these timesheets is significant. And I think what's important for us to understand is the times the crew showed up, the time they left at the end of the day, and that we pay them fairly for the services they provided. The administrative burden of recording every travel time element, every job they went to when they are moving dynamically from service to fuse cutout is a significant burden on our team. So I think as we look at this issue, streamlining that so that our crews that are focused on safety, focused on restoring customers, focused on communicating where they are can maintain their focus on that and not have additional administrative burden that may not be worth the cost. So again, in these events, we fully understand who came to our storm, how many they were. We fully understand the duration that they work for us, and we pay them a fair amount in response to that so that they will come back when we need them.
Okay, thank you. Was there anything else on that response, or is it? Should I move on? Okay. Is it the company's position that all travel time is billable, or does it depend on the contract?
So in the context of a storm?
Yes.
So if a crew is leaving their home location and coming to us to assist us in a storm, that travel time would be billable. And when they're here, if we're asking them to leave our facility and go to the first location of work and then move from location to location, yes, that travel time would be billable. So
Okay, thanks. So again, just responding to what we're reading, if you refer to redacted EOE 257, where EOE inquired about travel time being billable, and where the company's response concluded that the billing was correct. The contractor daily time report on page 3 of confidential 165, attachment 1, details an on-site start time of 5 a.m., box 6, and an end time of 11, box 7, totaling 6 hours. The same page includes 3 line items where box 25 denotes a total of 1 hour of travel between jobs and 6 hours of work time. And we're wondering, wouldn't the travel time from box 25 already be included in the start and end times reported in boxes 6 and 7? I know this is also specific. But
I'm sorry, sir. I lost you with, go back to the figure that you're referencing.
I was saying that
I'm sorry, which interrogatory response? Attachment?
257,
257?
yeah.
And that was EOE 257. Okay.
Yeah, about travel time and billing. Okay.
Actually, just on the numbers that Attorney Beckenstein was mentioning, he was talking about the contractor daily time report on page 3 of confidential EOE 165,
165.
attachment 1.
Right, okay. Attachment.
Sorry, yeah, 257 is connected to 165, which is the contractor daily time report on page 3.
Okay, and I'm sorry, now I've gotten myself to 165 attachment 1, and you were on page
3.
Page 3.
Yeah.
Okay. And this is a timesheet submitted by one of the crews.
Mhm. Yeah, if the boxes are numbered, if you look at box number 6.
My old eyes can't see the numbers. All right.
Yeah,
On
it's,
6,
it includes a start time of 5 a.m.
which would be typical in one of these events. Okay.
Okay, and box 7 has an end time of 11 o'clock. So that would be 6 hours.
Box 7. I mean, does it? See that? Are you looking at the unredacted version or the redacted version?
Just to be clear, Attorney Beckenstein, the hours on the timesheets are redacted in the redacted version. So just so
No,
we're,
this is the confidential version.
yes, I
Sorry
know.
about that.
And those are redacted in the public redacted version.
Okay,
Just
so-
that
so our-
most of the witnesses are looking at the right document.
Yep.
I just don't want to.
Okay, oh, well, I guess then my question is, are the times confidential?
They've been redacted. I do believe they tie out to the invoice that's provided that is redacted. So I think we we're trying to gauge that, but
Well, so I guess, I mean, EOE's position is, so we're not gonna tie them into anything specific like price or anything here. We're just talking about the time. We're just trying to make sure we understand. So we are looking at the unredacted version, but we're not going to make any links here. We're just really trying to understand the times.
we'll do I think we'll do our best to keep it on the public record. I think we can do this. Mr. Eves, do you have the unredacted version of that attachment?
Not, I'm looking at the
Okay.
redacted version.
So the question.
Give us a moment, Attorney.
Sure. This is really all we're trying to find out.
Thank you, Attorney. Okay, so
Without even looking at those specific boxes,
Yep.
the question is, would the travel time from box 25 already be included in the starting and ending times? That's really all I'm asking.
at 5 a.m. In a storm event, so this is the timesheet of a crew guide.
Okay,
So this individual is responsible for getting the work So we have a team of people that are working through the night, typically, putting together the work packages. This individual shows up at 5 a.m. to gather that work package and then go and meet the crews to get them moving. So this 5 a.m. start time, he is actively working at that time.
Okay.
And again, these events are not in our office. They're traveling to the events. That is a legitimate expense. Travel time back and forth to those things is a legitimate expense.
Okay, yeah, no, I just wanted to clarify that. Moving on, I'd like to consider I may be pronouncing this wrong, a Splendid Tree Expert LLC timesheet submissions. From,
Asplund.
this was from the flooding event on December 23rd, 2022. So it's EOE 262 and its attachments.
Yeah, let me be clear as well that it's termed flooding event. There was flooding that resulted from the wind pushing water into Long Island Sound, but this was a wind event that occurred the day before Christmas Eve. So there was, we had relatively significant outages on that day. Those around us had more, but it was more than a flooding response. And I'm sorry, you directed me to EOE 262 here?
I'm referencing the Splenda timesheet submission, which
Yes.
is included in 262. And the next few questions are based on a review of a sample of storm invoices, including that.
Okay. Is there a specific attachment?
Attachment 1. We looked at attachment 1, which is 29 pages, 2, and 3. 3 is the 87 pages. Those are confidential.
Correct.
So looking at the answer to 262, where it says, please refer to 262 UI attachment 1, okay, confidential. So the question that I want to ask is, can the company explain when a Splendid Tree was eligible to receive overtime and double time rates?
So Asplund crews work on our system on a typical daily basis. So if we call them into storm response during the typical workday, they will not get overtime. They'll be working at regular time. If they are being called from a distance to respond, so if they are not on-site crews, they will be paid overtime for that travel time. And if they work beyond their 8-hour shift into weekends or Sundays, and then depending on that duration, there are, contractual obligations for them around double time potentially.
I appreciate that. What are their, I guess, standard hours? If they're working for you kind of
Generally, they work 7 to 3:30.
7 to 3:30. Okay, thank you. And then is there, just kind of so I understand, okay, so overtime would be anything beyond that. When are double time rates? When do those?
And there's a number of situations where that can occur. So typically Sundays and holidays.
Okay.
And we were trying to determine, are these time reporting rules included in the contract in EOE 262, attachment 3? And if so, where would we find it?
That would require a review of the contract, so I think we can take that as a read-in and provide back to you.
Okay, great, thank you.
I believe we are up to read in X. Read in X.
Assuming a vendor employee works from
Just
5
to-
a.m.
Sorry, just to be clear, Attorney Beckenstein,
Okay.
sorry to cut you off. Is read in X for where in the contract the vendor timesheets are?
Oh, attachment 3?
Or the overtime requirement. We talked about overtime. So I'm just trying to make sure we have the right.
We're broadly looking for time reporting rules.
Yeah, and the overtime requirements.
Thank you very much. Apologies for cutting you off.
I'm sorry, I just couldn't hear what you were saying. The next question is, assuming a vendor employee works from 5 a.m. to 5 p.m. on a typical weekday, how many hours would be billed at the standard rate? We're just trying to understand what we're reading.
I'm sorry, sir. Again, the hypothetical you just raised, could you repeat it?
Sure. If a vendor employee, and there were several, works from 5 a.m. to 5 p.m. on a typical weekday, how many hours would be billed at a standard rate?
So they would typically begin at 7 o'clock, and anything outside of their 8-hour window would be overtime.
Regardless of hours worked?
What do you mean? I'm sorry.
So if all the contractor worked was, say, from 5 a.m. to 6 a.m., would that just be an hour of overtime versus an hour of standard time?
I mean, so if they're starting at 5 a.m., the 5 a.m. would likely, 5 a.m. to 7 would be overtime.
And then but they would also have to work their full standard day as well.
If it's a standard day. If it's not a Sunday, not a holiday.
But then they would be receiving double time rates, correct?
In the event, so this is they're working 10-hour days on a weekday. They showed up at 5 o'clock. They were scheduled to work 7 to 4:30 that day.
It's overtime still, yeah. Okay.
So in that 8-hour window, beginning at 7 o'clock, they would be billing us straight time.
Okay, so at the 8 hours starting at 7.
Start at 7. Now, if we call them in early for 5, they would get overtime on those 2 hours in the beginning of the day, and then they would get overtime on the back end if we kept them late.
Okay, I still wasn't, so I understand that. I guess what I'm still trying to figure out is, if they're called in, let's say they're called in early, understand they would get overtime. Would they get, but I guess my real question is would they get overtime regardless of whether they've worked the full standard day?
Yeah, if they're called in early, they would, correct.
Okay, so even if they didn't work the full standard day of,
Generally, they would, but if they didn't and they came in at 5 o'clock, they would still get those 2.5 hours overtime because it's outside of their scheduled day.
okay, so hypothetically, you could call them in from 5 to 7 in the morning, and then they already had they came in, they could make 2 hours of overtime, and they had a scheduled off day that day. Those would be 2 hours of overtime paid, not standard time.
Correct.
Okay.
Because it's outside of their normal work schedule.
Understood. I just making sure. Thank you.
Okay, I'd like to refer to confidential 262 UI attachment 2, which is on page 73.
I'm there.
We're noticing that there are 3 individuals working the same hours that are cited from 5 a.m. to 9 p.m. on a Friday. And we're trying to understand how these were billed differently at standard rates versus overtime rates. Specifically, it looks like one individual billed 9 hours at a standard rate, the remaining 7 overtime, while the other 2 billed 5 at standard, the remaining 11 is overtime. So we're just trying to understand if there's a rule.
Attorney Beckenstein, what page are you on here?
73.
73,
Mhm.
okay. 73 of 87, correct?
Yes, I believe so.
Okay. And you're pointing to the 3 individuals on this timesheet.
Yeah, there are 3 that work the same hours
Okay.
on a Friday. You see that?
Week ending 12/24, which was Christmas Eve. And Christmas was, in that year was what day?
I think it was the next day.
No,
I believe it was.
Okay, I mean, that's germane because Christmas would have been a holiday.
Yeah.
Attorney Vaughn, do you have the unredacted version in front of you? Okay. Okay.
Yeah. And I think this is the 23rd of December. Friday, I think, was the 23rd. So I would imagine the 25th was Sunday, and the holiday standard would probably be Monday following. So I think that's probably a regular day. Just
So the timesheet does not include the entire week, so the hours leading up to this would have bearing on what that individual charged. So when looking this, you don't have a complete data set to understand, why they would have charged overtime there. But in looking at it, that would be the likely explanation, the hours that were worked in the lead up to this event.
If you look at pages 67 to 71, there's other similar examples with 5 hours being billed at standard rates and 11 at overtime rates. Would that be the same explanation?
Each individual worker and their time for the week would be different potentially, yes. And I'll use this week as an example. As I was preparing for these hearings, on Saturday, if you remember, it was a very rainy day. We were mobilized to respond to storms. On Sunday, again, as I was preparing for this, there was a severe weather alert that came across. So these workers are working and being called in potentially many times during the week. And the hours that they worked in the lead up to an event like this will dictate their overtime, potentially.
sorry, I guess I'm just having a hard time understanding. So if people are billing the same hours for the day, I guess maybe I'm just not understanding in your explanation, but if they're billing the same exact hours for the day, I don't know how they can come up with different codes for that same time. That's really the crux of what I'm trying to understand. And I don't know, and I guess you mentioned maybe there's relevance to something that they did in other days, but I'm having a hard time understanding how that would be, how that would impact those hours of that day.
So there are a variety in rules, a variety of rules and dimensions to the overtime. There's the daily overtime. There's also the weekly allotment of going over, 40 or 45 hours in a week. that would drive them to overtime. So the individual's history leading up to that day is going to drive what he puts on his timesheet potentially. So, I mean, in a vacuum, you know, coming in cold to this timesheet, it's difficult for me to sit here and explain to you exactly why that number was charged there. The crew supervision that's working with these crews during the day would have that conversation. If they saw, you know, something like that, they would, we work with these crews every day. So why did you charge overtime? They would likely know what the guy did during the week. So they may know already why they're approving that. If you'd like to isolate a couple of these and we could get back to you with a late file as to why the charges are what they are, we'll go back and do the research on the other timesheets so we can show you why these timesheets meet, you know, the contracts and the rules that we have.
Yeah, I think that would be helpful just to understand. So if you need to show the whole week, right? So I guess then what we'd like to see is, you know, what are the specific overtime rules at play? And then if like, for example, here we're talking about EOE 262, attachment 2, page 73. We also noted same attachment, but at pages 67 through 71, where there are similar scenarios. So the overtime rules, and then if there are, like, you know, if the week is implicated as well, the timesheets for that week that could explain what we see as discrepancies here. That would be helpful to us.
Okay.
Does
And we understand that these events occur 24/7, and we're asking these individuals to respond immediately when they occur and to work the durations we need them to work. And with that comes some level of overtime. Okay.
Understood.
Okay, that's late file exhibit 40.
Thank you.
Referring again to confidential 262, attachment 2, page 73, we're trying to understand what the work description 22 MST1 means. Is there a specific designation for this? Is this a designation for a specific event? We also see the 22 STM, 23 TBL. We're just trying to understand what these mean.
So 20.
These are all page 73.
So 22 MST1 would be 2022 Major Storm 1. And what was the second reference you had?
22 STM.
That would be 22 Storm.
Okay. 23 TBL.
That'd be 2023 Trouble. So Trouble would be, we haven't declared a major storm, but we had them respond to a tree that came down on a blue sky day.
And lastly, 23 STM1.
2023 Storm 1.
Okay. Okay. Looking at the invoices, they appear, looking at all of the Esplenda invoices, they appear to include more than $64,000 of expenses that relate to activity that starts a week and a half after the storm event and spans for the next 4 months. The invoices include almost $4,000 of expenses that were prior to the storm, including activity that commenced, some of which was over a month prior to the event. And we're trying to understand how this activity would be related to the storm event.
So that was a long explanation. Could you repeat that? I'm sorry.
Yeah, just looking at the invoices, I believe there were 9 for Esplenda, and it's comes to over $64,000 that relate to activity that appears to have started both after and before the storm. So we're trying to understand what kind of activity that was, it's not clear to us what that was for.
Is there a specific page on a specific attachment that you'd like Mr. Eves to review and look at?
One moment.
This is more, the
Questions are a bit of a labyrinth of language and I guess, so fundamentally, we booked X amount of expense for asphalt tree services during this flooding event. And you're looking for the invoices that relate to that, to the dollars that we booked to that flooding event, correct?
Yeah, but the dates they're providing weren't when there was a flooding event. I mean, it's,
On the
Is
timesheets.
that a question?
right. The question is, it doesn't appear that the dates of the event are matched with the dates that the time is booked.
Yes, and I think I asked if there was a specific invoice that you'd like to discuss that it shows that, so that maybe Mr. Eves can look at it and provide you with a response.
This was all.
Looking at the invoices, it appears that there are invoices there that are not in the date range. So what I would recommend is we take a late file to review those invoices and ensure that we've lined up the invoices in that attachment. There may be more invoices in that attachment beyond what was actually booked to that storm and reconcile that.
That's
That'll
fine
work.
with us. Yes, absolutely. Thank you.
Okay, that's late file exhibit 41. And are we still on EOE 262?
Yes,
A specific attachment?
attachment 2.
Thank you, Mr. Eves.
okay. Moving on, if we could refer to EOE 258. With a Lewis contract included, that was another contractor.
Yes, that's a contractor that we use for tree clearance, correct?
Now, we notice the pricing schedule with that contract is references 2021. Was there a 2022 or was that a misprint? We're trying to, is there a more current pricing schedule or is that still the one in effect for the storm?
What page are you referring to, attorney?
258 attachment 2, one moment. We have it.
Sorry, just a moment.
You're referring to a master services agreement that was entered into on September 10, 2021, correct? That's
I believe
the,
so. I believe so.
beginning
Yeah.
of this 102-page document. Okay.
So we're wondering if that was the most recent period for a pricing schedule.
So, what page was that?
With any of this?
So on page 46 of that agreement, there is a table that delineates the rates through 2022.
Would you mind repeating the page? I just missed that, sorry.
Yeah, my colleague lost it as I was looking at it. I'm pretty sure it was 46 and. All right, nice egg. Okay. That yearly pricing begins on page 46, and I'm looking at the redacted version, and I can't see the titles of all of it, but somewhere in there would be UI. But this master service agreement would contain rates for the multiple years.
Okay, thank you. I'd like to consider the company's response to EOE 264, where it identified 174.5 overtime hours incorrectly charged to the storm, resulting in a removal of little over $13,000. We're just trying to get an idea of what the root cause of the error was.
So our line workers on a daily basis, I guess, first of all, make thousands and thousands of accurate charges. In these events, they're given accounting. That accounting string typically is a 6 to 8 digit number. Our supervisors are reviewing their timesheets, and they're kind of looking at the trees in the forest every day. So as you're doing this work, we have a storm today. An accounting number would be handed out for that. They may go back to that accounting number for that storm to do the follow-up work resulting from that storm. Depending on how big it was, we may partially restore something and have to go back a couple days later. Generally, when we have these events, work backs up, so our scheduled work can't be done on those days that we're responding to a major weather event. So we have a backlog of scheduled work that we need to chew through. And then depending on the priority and risk associated with the thing we left in partial restoration, we could go back to that days or weeks later. So there is potential for our line workers to be going back to a storm multiple days later. Our process right now is to have our supervisors looking at these timesheets on a daily basis. And again, they may have 15 or 20 crews reporting to them, each one of those crews charging 10 or 15 work orders a day. There is some potential for human error there. And we did find some of that in reviewing these charges. We are working internally to look at putting a process in place to look at these over time. Because one of the issues is you have to step back, weeks or months after the storm and ensure that nobody is continuing to use that number if it remains open. And we do need to leave them open because there are charges that could occur to those work orders down the path. So in this case, there were hours charged to that storm order beyond the time frame, but in general, thousands and thousands of hours are going to the right work orders every day. And this is an area that we could improve and will.
Okay, thank you. We're just trying to understand better the quote lean-in costs, wondering whether there were remediation efforts were performed by this company for this storm. And would that be part of overtime costs, or are overtime costs included in the lean-in event charges? We're just trying to distinguish between the different kinds of costs.
So Hurricane Lee was predicted to be a major weather event, actually a catastrophic weather event on Connecticut in the days leading up to the storm. I recall this vividly because I woke up at 4 o'clock on Friday morning, as that storm was approaching, it made landfall on Sunday. The National Hurricane Service placed a full hurricane west of New Haven at that time, which is a bullseye on us. So we prepared for this one significantly. So there were overtime costs in having crews travel to our location to be ready. By the grace of God, it went to the east, and we did not have significant weather. We did have some weather, and we did have some restoration, but it was minor. So there would have been costs incurred in that restoration, but it was not the catastrophic event that was predicted on Friday.
So it's fair to say that some of the overtime would be for remediation and some was related more to lean in.
Yes, there would have been a combination of both in that event.
Does the company differentiate employees supporting staging or lean in versus those performing remediation?
I guess, so understanding that, I guess, if there were storm remediation, why weren't those, why weren't those overtime hours excluded from the lean-in event? If there was.
Well, I guess the concept of lean in is a little bit of an external perspective, right? For us, it's an event. We need to prepare for the event, and then we need to respond when it occurs. Now, we had staged a number of contractors for that event. This one's a little unique because it was predicted to be so large and it was so small. So the response that we made, and the number of events that we got, we were able to generally use our internal crews to respond to the events that occurred. So the contractors were primarily lean in. So they were not engaged. We brought them in to be ready. They were here. But I think for the most part, we're not engaged, but there may be some slight contradictions to that.
Thank you. If I could refer you to the company's response to EOE 260, and that identified 27 and a half hours that were incorrectly charged to the storm, which resulted in a removal of about just under $2,500. Can the company explain what the root cause of that error was?
That error was a 2-digit transposition in that 8-digit number that the lineman mistakenly made.
Okay, thank you. And I guess my next question is, can you explain how the OT costs presented in EOE 260 attachment 1 were derived? And maybe just as, how does the company determine the specific rate for overtime?
The rate for overtime is driven by our bargaining unit agreement with the union. So the rules around this attachment is referring to internal labor. So we have a bargaining unit contract with our workforce that defines the rules around overtime and their rates of pay. What you see on this sheet are the hours, and those hours multiplied by the average activity code for that job description.
Okay. So I guess maybe a follow-up is, are the employees paid a straight hourly rate equivalent, or do they receive an incremental amount such as time and a half?
That depends on their work history and what they were doing the night before. So they will get overtime based upon the bargaining unit contract. Generally, our management employees will get straight time if they work a storm event. If they're below a certain level, directors and above will not get paid, but Supervisors will get paid straight time generally. And then our bargaining unit contract and in the hours that they work leading up to that and through the event will define what their overtime levels are, be it straight time, time and a half, rest time,
Okay, so
et cetera.
I appreciate that. So basically, different employees can have a different amount and a different
Yeah,
potential,
They're all-
how they're going to be paid is going to vary employee to employee.
They're all unique and, they may have been they may have been clearing roads for a town and were held up until 10 PM while they worked with that municipality and worked, hours in the preceding day. That will have a bearing on their overtime the next day. So people on the same crew and, kind of going back to that other example, I mean, internally, that can happen. You did something last night, you weren't part of that crew last night, but now today that's driving your overtime under the bargaining unit contract. It can look different even though they're on the same crew.
Okay, thank you. So, kind of the last thing, and maybe it relates to before, but just trying to understand the maximum number of overtime hours that an employee could incur on any given day. So, sorry, I think everyone would agree that there's only 24 hours in a single day. I guess my trouble, if I'm looking at EOE 260 UI attachment 1, and I'm looking at employee, I guess it's an 18. It looks like he incurred 33 hours of overtime on December 24th. And then 26 hours of overtime.
Yep.
On December 23rd. Could you explain that to
So-
me?
So we group a number of different pay codes into the overtime hours here. One of the things that could generate more than 24 hours is the individual was on vacation. So there's a vacation call-in code. If they're scheduled for a vacation and we call them into storm work under the bargaining unit contract, there are elements of compensation that they get for that. So that could result in a 24-hour or in a greater than 24-hour charge on a given day. Generally, in a multi-day event, we will work our crews 16 hours and they will sleep for 8. In certain instances, we will work a crew on the first day 24 hours. So it is possible. It's rare. We try not to do it, but if they are engaged in something and they can complete it within the 24-hour window, we will allow that on the first day. And so that is how a combination of those two things, that individual is likely scheduled for vacation the day before Christmas Eve and Christmas Eve and came in to aid in the response, which our people often do.
Okay, so, sorry, so this would essentially, and I understand it's based on bargaining unit rules, and I understand these dates are, Christmas Eve and the Friday, the 23rd. This could essentially only happen on concurrent with a holiday. Is that correct?
Or if the individual is scheduled for vacation.
Or a previously scheduled vacation.
Correct.
And so then their hours that they could bill for a day could go over the 24 hours because they would have to include.
The time codes that went into overtime hours could exceed 24, yes. And let's, again, I want to
Okay.
kind of jump out of the numbers here back to the reality of what we deal with, right? This was 50 or 60 mile an hour winds predicted the day before Christmas Eve going into Christmas Eve. And our people left vacation and came, left their families, came in, worked, restored power until the end of the day on Christmas Eve. The storm that impacted us only created about 8,000 outages. Eversource was at about 100,000 that day, and our main affiliate was up at 400,000. So our people not only came off of vacation to support our customers, they worked through Christmas Eve. They went home, had Christmas morning with their families until about 5 a.m. and then left to go to Maine. And we're there for almost a week responding to this. So all of these, and we've been through, a lot of the administration behind the timesheets and all those things. That is the work that's occurring here with these charges. And the charges are voluminous. We're doing this, multiple times a month, mobilizing our resources to respond in these events.
Okay, and I just, all of this would be laid out in the collective bargaining contract. I'm not asking for it.
Correct.
I guess I just want to make sure that that's your position. And I served on the USS Eisenhower, so I appreciate the Eisenhower quote earlier. That's all I have. Do you have anything else? It's all across for EOE. Thank you.
Thank you.
Thank you. Next, Attorney Wright. Attorney Nigro. Thank you. Commissioner Karen? No. I also don't have any questions. Thank you. Does the company need a moment to consider redirect?
Yeah, could we take 5 minutes?
Sure. Oh, the cold, yeah.
Thank you, Chair Gillette, for the brief intermission. We have no redirect for this panel.
Okay, thank you. Then this panel is excused and we will transition to the company's revenue requirements panel on page 11.
Chair Gillette and Commissioner Karen, while everyone gets settled, I did just want to note, as you can see, we've identified our main panel witnesses for this panel, and we do have quite a few discovery witnesses identified. So consistent with how we approach it in the RAM, our plan will be to have our main panel witnesses sworn in, adopt their materials, and adopt the discovery responses, and then perhaps shift people up as necessary with, depending on the topic of the questioning. So just to give kind of a heads up, just to, as we've done it in the past.
I appreciate that. If, in that case, if anyone that you think might be called up can be identified and sworn for efficiency. I mean, is that what you're suggesting that?
No, it's not. I was thinking that we would, we're endeavoring to minimize anyone additionally being called up. Just so, if they have to support the panel witnesses, I think is what I was more getting at.
Got it. Okay, thank you. Then when you're ready, please introduce your panel. Or when they're ready.
Thank you. I would ask the main panel witnesses, beginning with Mr. Dane, to introduce themselves and please state their full names and positions for the record, followed by Mr. Boria.
Good morning, Daniel Dane. I'm the president of Concentric Energy Advisors.
Andrea Van Lilly, Networks Controller here on behalf of UI.
Jacob Hurwitz, Senior Director of Revenue Requirements, here on behalf of UI.
Laura Wakefield, Director, Revenue Requirements.
Michael Barea, Senior Manager, Delivery Programs and Products on behalf of UI.
Thank you. And Mr. Hurwitz and Ms. Van Lilly, I believe you were previously sworn and adopted your pre-filed materials.
Okay, if the new witnesses could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
Ms. Wakefield and Mr. Dane, as part of your preparation for this docket, did each of you co-sponsor pre-filed direct and rebuttal testimony and exhibits in this proceeding, which were marked as exhibits UI RRP 1 through 27 and exhibits UI Rebuttal 1 through UI Rebuttal 5?
Yes.
Yes.
And did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in interrogatory responses?
No.
No.
And do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
And to the main witnesses on the panel, excluding Mr. Barea, for the purposes of admission into the record, have you reviewed and do you adopt the interrogatory responses submitted by the other individuals identified in the company's April 24th, 2025 letter on witness panels in the area of revenue requirements?
Yes. Yes.
Mr. Barea, as part of your preparation for this docket, did you provide pre-filed rebuttal testimony and exhibits which were marked as exhibits UI WHRP 1 through 3?
Yes.
Did you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Do you have any updates or corrections to your pre-filed testimony or interrogatory responses not previously identified for the record in an interrogatory response?
I do not.
And do you adopt your pre-filed testimony and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Thank you. The panel is available for cross-examination, and Mr. Barea, you can return to the gallery. Thank you.
Thank you. We will begin cross-examination of this panel by authority staff. Attorney Riley, please.
Thank you, Chairman. Good morning to the panel. I'm going to start today with RRU 242 Attachment 1. And to level set, this corresponds with Schedule WPC 3.06, Line 1, the Professional Services tab, or line item.
I am there.
Okay, thank you. So I want to ask a foundational question here. So how does the company determine which items flow into this outside service line item? And how does the company ensure that it's not double counting certain line items, and whether there's specific criteria for how these line items, and maybe perhaps I'll illustrate some of the breakdowns in 242 attachment 1 to help our discussion. So I noticed there were descriptions there such as poll attachments, EXP, electric ops, admin OM, and that left me questioning why those aren't reported in distribution outside services or some other line item in the application.
So I'll start by just providing a broad overview as to how we develop the unadjusted historical test year figures that we present in the revenue requirement, and provide some insight into how we categorize them between the various schedules, and then maybe we go from there. By way of background, as you likely know, the revenue requirement begins with an unadjusted historical test year, and that is directly from our accounting system. Our system of record is SAP. And we begin with this big, massive extract of all of the information underlying the income statement, and then do our best to assign all of the elements of the company's revenues and expenses to the various schedules of the revenue requirement to the extent they belong in the revenue requirement. Some things such as interest expense do not, because we recalculate interest expense to be synchronized with rate base in this proceeding. But in that way, we effectively guarantee that at least in the unadjusted historical test year, there is no dollar that's counted twice, because every line of the income statement is assigned to one and only one place in the revenue requirement. As part of that, we do our best to make judgments as to which schedule within the revenue requirement amounts belong. For example, we have a collection of outside service schedules, and in docket number 220808, I think we broke down those outside service schedules between, I don't know, 6, 7, maybe 8 different subschedules. In this case, to better align with how the company operates and the different groups of the company incurring the expenses, we thought it appropriate to consolidate that to a smaller number of schedules and reflect a combination of lines on that smaller subset of schedules. And in doing so, we try to assign expenses to the place where they belong. Now, this particular line item that you've pointed us to, the reference to electric operations, I would have to look into that line specifically to see if that was, a professional service incurred by that group. And this is just an order description. This is a little too specific for me to know off the top of my head, but by way of background, that's how it works. And that was our overall approach.
Okay, thank you. So if I'm distilling your answer, your SAP system takes the revenue requirement as a whole, and the company is able to avoid double counting of these expenses because their system is able to delineate like all of these different line items.
I think you got the causality a little bit.
Yeah.
The steps, the process order a little bit.
Yeah,
flipped
a little
there.
bit, yeah.
So if we did not file a rate case and we're not here, the company would continue maintaining its books, of course. And in the process of doing so, the company would be developing income statement data and balance sheet data and maintaining that in its system of record. And that system of record then forms the basis of financial statements and a whole host of other things. Using RRU 241 UI attachment 1 as an example, you can see this attachment includes something on the order of 30 lines of pretty detailed accounting data. It includes an order number and a cost element. But because of the specific request in this case, it's a very limited subset of the income statement data. There's a tens of thousands of row spreadsheet of the data underlying the actual income statement, and that's what we take and try to divvy up between the revenue requirement schedules. The creation of the revenue requirement schedule happens after the company has developed its books for the particular period.
Okay, thank Thank you. I appreciate the response. While we're on 242 line 1, so to be clear, company line 1, Excel line 7, the order description UI support, do you know what consists of that expense, or would you need to look further since that's just an order description?
Give me just 5 seconds. We'll see if we
Sure.
can dig that up real quick. We do not have that much more detail at our fingertips, so we would have to look into this further.
Yeah. Okay. I'll take it as a late file. So, Chair Gillette, the late file request is for RRU 242 attachment 1, the order description UI support. If the company could provide a breakdown and description of items included in that line item for the rate year. So actually, could we do test year and rate year while we're at it?
We would be happy to provide both. The breakdown will be the same, and the rate year will simply equal the test year
Test
escalated
year,
by
yeah.
inflation, but we have no issue providing both.
Yeah, thank you.
At LFE 42.
That's what I had.
Late file exhibit 42.
So next, we're going to move to professional services, specifically the operational smart grids line item. And I'll turn the panel's attention to RSR 309, attachment 1, page 4.
We are there.
Okay, and I think we're looking at column I. And the authority was hoping to just hopefully have a breakdown or a walkthrough of how the formula used to calculate that rate year adjustment.
Just one moment. So I think the clearest walkthrough of that will be Schedule C 3.06, footnote 2 on numbered lines 15 through 17 of that schedule. And as described therein, broadly, the adjustments to this line of the revenue requirement include 3 things. First, a $170,000 reduction for outside service costs that the company incurred in the historical test year, but does not expect to incur in the rate year. Second, a $580,000 increase related to contractual escalations in our contract with Landis and Gear, the MDMS vendor for our meters. And then third, an inflationary adjustment for the remaining costs reflected in this line item. And my recollection is it is the Landis and Gear portion that is the lion's share of this line. I think it's something on the order of 4 million of the 5 million reflected here. You can see on Schedule C 3.06 that the difference between the rate year value of 5.093 million and the test year value of 4.642 million is approximately $450,000, which is the exact same as the total adjustment shown on the attachment you pointed us to, RRU 309 UI attachment 1, page 4. And if you review the individual line items comprising that total, you'll see that the lion's share of those line items are simple, by lion's share in terms of like quantity of lines, not in terms of dollars. The lion's share of those line items are simply the test year pro forma escalated by inflation. However, where those line items relate to the two adjustments I described earlier that are not related to inflation, there's a more specific formula where we have attempted to illustrate exactly how our pro forma adjustment relates to that specific order. Because as I described a minute ago, there could be a collection of orders that, there are a collection of orders that have been added up to that line item.
Okay, thank you. And while we're on 309 attachment 1, all of the costs reported in the exhibit are external costs, correct? Paid, in other words, payments to outside vendors.
That is, if you were asking about that specific line, that is correct. If
Yeah.
you were asking about C 3.06 as a whole, that is largely correct with one exception. There is a line for services performed by affiliates, which are affiliated to the company.
Yeah, understood. Thank you. And then once again, related to RSR 309, attachment 1, page 4, I believe there's corresponding vendors that were provided on RSR 308, attachment 1. And I think probably what would be helpful to the authority here is if the company would be willing to do a late file for an additional column to RSR 309, attachment 1, page 4, that indicates the corresponding vendors that were disclosed on RSR 308, attachment 1. That makes sense. Yeah, thank you.
Late file exhibit 43.
Yeah. And again, just for the record, that's an additional column to RSR 309, attachment 1, page 4, that indicates the corresponding vendors as indicated in RSR 308, attachment 1. Okay. And now I'm going to change topics to legal expenses. And I'll begin with RRU 222, supplement UI attachment 1.
I am there.
Okay, so there's two matters listed on this. I'm looking at line 13 to be specific. So there's there appears to be two Superior Court cases, UI versus Kazarin Luis et al., UI versus Romeo Simeon et al. So my question is, were the matters identified on those lines resolved in the test year?
One moment.
Sure.
We would have to check.
Subject to check, it appears that there were both default judgments entered in favor of the company. So I think maybe that could just be confirmed via read-in if those are default judgments that were entered for the defendant or for the company, rather.
Read and why?
It was Excel line 13.
That's correct. And then I have a similar question for line 43. There's a number of matters listed there. So I think given the amount of matters listed on line 43, maybe we just take that as a late file with similar explanations as provided in ADJ 001 and 002, if that makes sense.
I Paul.
I mean, if the company thinks they could get that as a read, and that's fine as well. But I think let's, for simplicity, let's just keep it a late file.
There's a few matters here, as you noted, so.
Yes.
I apologize, Attorney Riley. I think we're up to late file exhibit 44, but could you please restate?
Absolutely, Chair. So we're on RRU 222 Supplement UI Attachment 1, line 43. The question to the company is, were the matters identified in that line item resolved in the test year? And if they could provide similar explanation as provided in ADJ 001 and 002. Okay. So I'll move now to ADJ 002.
I am there.
So can the company indicate what the Old Town substation rebuild project is and why the company is incurring legal expense in relation to the project?
One moment.
Chuck Hughes, Vice President Electric Ops. In 220808, we proposed the rebuild of Old Town Substation. As a result of the outcome of that rate case, that program has been deferred, but we are still in the site and council process, trying to prepare that. We have included it in this case and hope to begin with that rebuild to support the residents of Bridgeport and Trumbull. So those legal expenses would have been incurred in that site and council process.
Okay, so they're confined to site and council matters.
I mean, the matters regarding the project that I think the predominant impact would have been the site and council process that project is currently going through.
Okay, understood. Thank you, Mr. Hughes. And this is a procurement question. So how does the company select its law firm's representation, and does it engage in a competitive RFP process followed by entering into retainer agreements?
Chair Gillette, we do have Mr. Lavulo, who you may recall from prior rate cases, who is, it's kind of going to be okay. We do have Ms. Hagan here, who could be sworn. She was identified as a discovery witness, and she can be sworn in to address this question.
Okay, Attorney Hagan, if you could please raise your right hand. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you.
So Attorney Hagan, I'll restate the question for you. So how does the company select its law firms that represent it, and does the company engage in a competitive bidding process followed by entering into retainer agreements for those law firms?
Yeah, there are a few different ways that we can engage and do engage external counsel. There are instances where we will do a competitive RFP and solicit estimates back from firms, but it also can be based on subject matter expertise, familiarity with a recurring issue in terms of efficiency, skill and expertise of a particular firm or lawyer that's needed for the item. And so we're really looking at what is the best match for the legal need that we have.
Okay, so conceivably they could be sole sourced.
Exactly.
Okay, thank you. And I'll turn our attention to RRU 222 Supplement UI Attachment 1. And my question here will be, are the retainer agreements or contracts in place for the law firms identified in RU 222 supplement UI attachment 1?
Yes.
Okay, thank you. So are judgments, legal judgments for or against the company or legal settlements reflected above or below the line?
It depends.
Can you explain further?
Yeah, it depends on the circumstances surrounding the case and what the underlying reason is and what the ultimate settlement is. But there's no accounting rule saying that it would go above or below the line.
Okay, so above the line, does that ultimately matriculate down to costs borne by ratepayers?
Not necessarily.
Okay,
Things above the line, below the line tends to be used to insinuate what would go to ratepayers and what would go not to ratepayers. Above the line meaning that it would go to ratepayers, below the line meaning that it would not go to ratepayers. But something could be above the line that's taken out of the revenue requirement and it would not go to ratepayers. So just because something's above the line doesn't mean that we're seeking recovery of it.
oh, I appreciate the clarification. Thank you. So I'll restate my question then to whether legal judgments or settlements ultimately are paid for by ratepayers, either at the company level or above, like it's UIL, et cetera, any entity seeking recovery in this rate case.
So if you're asking about current ratepayers, then that would be dependent on what ended up in 220808. That was included within the revenue requirement for any legal settlements. I'd have to go back and check and see if there was anything, but that's what would, in theory, be right now being recovered from ratepayers.
And I'll also make a distinction here too. Is it to make sure we're just on the same page, the distinction between legal expenses, so engaging law firms, et cetera, to represent the company versus judgments rendered either after trial or settlements, et cetera. Are we on the same page with
Yep.
what those expenses are? Okay,
Yes.
thank you. Move on.
So just to add on, OCC 307A does include my eyes aren't that good. In OCC 307A, table, subsection B, there is a table that has the total amount of settlement payments by year and the amounts that are included in the test year and the rate year.
Very good, thank you. So I'll turn to audit expenses. And my understanding is the company had previously indicated that auditors were not selected for the rate year. Have auditors been selected for the rate year?
Subject to check, I'm 99% sure they were just confirmed at the last audit committee meeting. But if I could just read it and confirm that for you, that would be helpful.
Okay, so we'll read that in, and then if it's in the affirmative, I would ask for the updated pricing terms and engagement letters.
Okay, if that's what you're looking for, that I am 99.99% sure that we do not have those yet because we're still in negotiation on the pricing with the auditors. But I'll do the same with the read-in, but I'm fairly confident we haven't finalized the pricing.
Okay, thank you.
Okay, it's read in Z.
Next, going to turn to IT security and safety expenses. RU 220 attachment 1, specifically line 13.
There.
So how does the company procure its security? I understand this line item to be related to security guard outside expenses. How often does the company release a competitive RFP, and when was the last time the company performed one?
One moment.
One moment. Every 3 years, and we just entered into a new one in 2025.
Okay, so then that'll be effective in the rate year, then, correct?
Correct.
Thank you. Line 12, same interrogatory attachment, 220 attachment 1. Similar question here. How's the vendor for these services procured? And then there was a CLM descriptor here. So how is that cost divided between CLM and non-CLM uses?
I can answer the second part of that, and then I'll have to go check with someone on the first. The second part, as we described in, I think, 1 or 2 interrogatory responses, well, the label for this line item clearly is CLM, and CLM costs are recovered outside of base rates. The portion that is reflected in distribution here is the portion that is utilized by groups of the company outside of the CLM group for non-CLM services. So they use a similar or the same system for different things, and that's why there's some of this cost reflected in distribution despite the CLM label. But I'll need to check with someone in the audience with respect to your question on procurement. Just one moment.
Understood. Thank you.
This particular vendor was selected through a competitive RFP process.
Okay, and those expenses are in place for the rate year? Or the contracts in place for the rate year?
One second.
Right.
We will have to check just how much longer that particular contract lasts.
Okay. Do you think that could be accomplished via a read-in? Okay, thank you.
Okay, read in AA.
Moving now to RRU 359, related to board of directors.
We are there.
So the company cites to a number of statutes for the proposition that it requires a board of directors. Is there any legal requirement that the company is aware of that requires a board of directors to be external rather than internal?
Just to be clear, the witnesses are not lawyers, so I think they can
Understood.
give their, factual understanding of that question.
Yeah.
Yeah, I'm not a lawyer, so I'm unaware of any requirements that they would need to be external and not internal.
Okay. Has the company explored or done a cost comparison of utilizing external versus internal board now that it's Avangrid's delisted?
There's various different levels of boards that can be in any type of company, as you know, and as we have here. I'm unaware of any company ever, and I have 13 years of experience at PricewaterhouseCoopers before coming to Avangrid, of any company that is fully all internal board of directors. Usually, there is merits and value to having independent directors that might sit alongside your internal directors, but I am unaware that you would ever have nowhere in a company a fully in-house. So to answer your question, no, we have not done an analysis of what the cost savings would be, but in my personal view, and again, I'm not a lawyer, it would be very abnormal for that to be a situation.
Understood. Thank you. I'm going to move to shared services. Specifically, we're going to look at Schedule C 2.2, page 1.
That 2.2A. I'll take a very educated guess that it is actually.
Oh, okay. Thank you. I didn't specifically reference in my outline, but
There's a C point 2.2B, but it's not very interesting.
okay. Thank you. So I understand there to be in certain instances throughout the application, there's an 85.48% wage allocator applied, as well as a 79.16, depending on various scenarios. Is that a general understanding?
That's
Correct.
generally correct. Both of the percentages that you see in bold on numbered line 10 on Schedule C 2.2A are reflected in various places in the proposed revenue requirement.
Okay, thank you. Would the company be able to indicate in the schedules throughout its application with specific cell references, whether the 85.48 or the 79.16% wage allocator was applied in determining the revenue requirement?
I can indicate that the only schedule in which the 85.48% is reflected is Schedule C 3.15, the compensation schedule. That then has the flow through effective, meaning that percentage is effectively reflected on C 3.16, the benefit schedule, but that is the only schedule where it appears. And the reason for that is, and we discussed this in testimony, a couple of data requests, and to some extent with, I think it was the OCC a couple of days ago. The reason for that is because the nature of the expenses across the schedule differ. The difference between those two percentages is the 85% reflects data only at the UI level, whereas the 79.61% reflects data at the UI level and costs allocated to UI from the service companies. 79.6% is generally the appropriate percentage to apply for purposes of splitting costs between transmission and distribution, because that's the allocator that's used through the company's formula rates, the split costs. There are, of course, plant revenue and Massachusetts formula allocators that are also appropriate depending on the FERC account. However, the reason we applied a different allocator on C 3.15 is because that schedule reflects purely costs at the UI level. And so we felt it appropriate to reflect the pure UI allocation percentage.
Thank you. I appreciate the explanation, Mr. Horwitz. I think the authority is still going to seek the specific schedules for that 79.16 appears in the company's application. And I'm assuming we would need to take a late file for that.
Yeah, we can put something together.
Okay, thank you.
Okay, so late file exhibit 45 is to provide the list of schedules where the 79% wage allocator is used.
And self-references, please.
I will say it's going to be tough for us to identify specific test year cell references where this allocation factor is applied. I think we described in a couple of data request responses that the allocation is done automatically in the company system. And so there's not going to be a cell that is, this is the total times this is 79.6%. There will be some times where it discretely appears for rate year costs that need to be allocated, and we can identify those, and we can provide some insight into how the test year allocation was done, but we're not going to be able to point to cell, just to make it up, G17 on Schedule C 3.03. You can see this percentage here but I think we can put something together, and I think I understand what you're seeking.
Thank you. Yes, much appreciated. And then I think similarly, I understand that there's also a 61.78% and a 63.93% figure used in the company's application. Is that correct?
Those sound like Massachusetts formula values from Schedule B 2.4. Is that what you're referencing?
Yes, page 2, yes.
And I'm sorry, I was so focused on understanding the numbers, I missed what your question was.
It was just a foundational question just to understand that those figures represented the Massachusetts formula. So you've answered, thank you. I think similarly here too, what the authority is seeking is to indicate on all schedules with specific cell references whether the 61.78 or 63.93% Massachusetts formula allocators are used to determine the proposed revenue requirement. And if any other percentages on Schedule B 2.3, page 2 of 2, 2.4, thank you. Page 2 of 2.4, yes. Correct. Apologies, Schedule B 2.4, page 2 of 2, used in determining the proposed revenue requirement, indicate the percentage used and with the specific cell references. So I know that was lengthy. If you need me to read that back to you, or do you understand the request?
Just to say back to you what I'm hearing, you're looking for something that is tremendously similar to LFE 45, but for these Massachusetts formula percentages.
That's correct.
I gotcha. And just to, again, provide a little brief insight now, the differences between those two percentages, the 61.78 and the 63.93, is the level of the Massachusetts formula. The Massachusetts formula is simply allocation derived from plant payroll and revenue. You could apply it to any number of universes of companies and get the appropriate resulting allocators. The 61.78% is the UI portion of the Massachusetts formula as it is applied to UI, CNG, and SCG. So when costs are getting split between those three entities using the Massachusetts formula, that's the percentage that's applied. And I think you see that on some of our corporate service charge schedules for that reason. In contrast, the 61.78% reflects the UI distribution portion of the Massachusetts formula as that allocation process is applied just to UI and its distribution and transmission operations. So that's just a little high level insight into why those percentages differ, but we can put together some materials for you in a late file.
Okay, great. And I think I'll just make sure I clarify for the record what we're seeking. So this is examining Schedule C. Schedule B 2.4, page 2 of 2. And the authority is looking for the company to indicate in all schedules with specific cell references whether the 61.78% or the 63.93% Massachusetts formula allocation figure is used to determine the proposed revenue requirement. If any other percentages used, as well as any other percentages used in determining the proposed revenue requirement.
Thank you. That's late file exhibit 46.
Thank you. So we're staying on the C schedules, Schedule C 3.18, WP.
We are there.
Okay. And specifically, page 1, line 2, there's a approximately $5,057,000 figure reported on that line. Is that figure included in the $8,867,609 figure reported on page 2, line 12, column E of the same schedule?
No, those are different things. Schedule C 3.18, page 1, line 2, the 5,057,000 you referenced reflects charges directly from ASC to UI, directly from ASC to UI. In contrast, the $8,868,000 approximately reflected on Schedule C 3.18, page 2, line 12 reflects direct charges to UI from UIL.
Okay. So I'll move to same schedule. There's approximately $4,724,000 figure on line 7. And that figure is for Berkshire. I'm sorry, so that figure on line 7 for Berkshire is from UIL and not ASC, is that correct?
These charges are UIL level charges, that's correct.
Okay.
Although as we described in a data request whose number eludes me, a portion of this reflects a fixed charge to Berkshire that is not the sum of specific services, but these are reflected in the UIL allocation process.
Thank you. Staying on the same schedule is the, again, going back, there's the approximately $4,274,000 figure. Is that figure included in the approximately $34,524,000 figure on line 2, or the $66,027,000 figure on line 1?
Just point me to the first number you were identifying again, please.
Yes, it was approximately $4,274,000.
Where was that?
It's the Berkshire, sorry, line 7, the same Berkshire figure we were discussing earlier.
And you said 4.2? I see 4.724.
I think I have my numbers reversed. Thank you. Yeah.
And I'm sorry, I was just distracted by that. Could you please repeat your question?
Yes. So is that 472 figure included in the 34,524,000 figure on line 2, or the approximately $66 million figure reported on line 1?
The approximately $4.7 million figure reflected on line 7, as I described a moment ago, relates to UIL costs. So that is getting backed out of line 2. And that 4.7 million is not something that we are seeking to recover in this proceeding.
Okay, thank you. Sticking to the same schedule, was the approximately 8,867,000 figure on line 12. Actually, maybe I'll let you find the figure first.
I see that one.
Okay, thank you. Is that directly charged to UI by UIL used to determine the 29,342,000 figure on line 14, which is the total allocated to UI distribution?
My apologies. Could you repeat the number that you said?
Absolutely. So we're first looking at the 8,867,000 figure on line 12.
And I'm sorry,
And-
but just distracted. We see 8.868. That is extremely close to what you said, but
Okay,
we
yeah,
see
thank you.
0.868 million.
Oh, thank you. Was it directly charged to UIL by UIL, or was that figure on line 12 directly charged to UI by UIL used to determine the 29,342 figure on line 14, which is the total allocated to UI distribution?
One moment. Thank you for the patience. Yes, these direct charges would have been a component of the 29.342 million reflected on numbered line 14 down below.
Thank you. We're going to move next to RU 399, attachment 1, as well as exhibit UI RRP 20.
We are there.
Thank you. Exhibit UI RRP 20, we're looking at the $8,867,000 figure. And specifically, which line in exhibit UI RRP 20 is the approximately $8,867,000 figure reflected in as reported in line 94, column F of RRU 399, attachment 1.
Thank you for the patience, Attorney Riley. I don't know that there will be a discrete combination of lines that you can add up on Exhibit RRP 20 to exactly match the 8.868 million. My suspicion, subject to check, is that the portion of that amount is embedded on numbered line 31 of Exhibit UI RRP 20, page 1, and some of the amounts below are also included, but I think there's going to be some embedded information that you won't be able to add up the numbers you see here to get that number on that other schedule.
I'm going to defer to my colleague, Mr. Bakari, for a moment.
If you go back to C318, there was a discussion earlier about the $8.68 million. What we're trying to identify in RRP 20, which I believe you referenced line 31, that's which line contained that $8 million? So that's what we're trying to get to, because that's part of the amount that was indirectly allocated to UI distribution.
I think I understand what you're seeking, and I don't know that you're going to be able to add up the numbers that you see on Exhibit UI RRP 20 to exactly match that 8.8 million, because I think RRP 20 is derived by GL account in a way that reconciles exactly to UI's for Form 1. In contrast, Schedule C 3.18 is a slightly different presentation of similar data. So I think the view that we've provided in RRP 20 is going to be difficult to add up the numbers to get to that exact 8.8 million, if that makes sense.
Okay, I get you. Correct me if I'm wrong. Earlier, you just said that the $29 million that was indirectly allocated to UI distribution included the base included the $8 million as part of the amount that was indirectly allocated to UI distribution. And if your support is RRP 20, where you determine the $29 million, I believe that $29 million is coming from RRP 20.
We could, and you can see the 430 million reflected on Exhibit UI RRP 20, for example, in cell P65. But to discretely identify that 8.8 million, I think we'd have to prepare a different document for you.
Okay, thank you. That's all. You can continue with the next.
Do you need a document prepared for you?
I think we're okay.
You're okay.
Yeah.
Okay. Thank you. So we're sticking with same interrogatory responses as well as Schedule C 3.18 WP. And our question here is, can the company identify where in Schedule WPC 3.18 the company includes the approximately 2.546 figure reported in RRU 339 attachment 1, Excel line 94, column G, as being directly allocated to UI distribution? And I can give you the RRU 339 reference again if you need be.
One moment. Could I trouble you to repeat? It was RRU 399?
339. Attachment 1. 399.
Yeah.
Oh, my apologies, Mr. Hoare. It's 399.
And it was cell G94?
That's correct.
It was, can we identify where this is reflected in C 3.18?
That's correct, yes.
Thank you for this question, Attorney Riley, because I was actually looking for this data request in response to one of your earlier questions. I had recalled providing something along these lines, but couldn't identify this exact attachment on the fly. But this, I think, illustrates sort of what you were asking about a minute ago. How does the 8.868 million fit into that 29.4 million. And this attachment shows exactly that. This shows in Excel column F, the components of that 8.868 million, and it shows all of the individual line items and GL accounts and, orders that comprise that amount up above. And you can see that 8.868 million total in Excel column F. And then you can see for each discrete line item, whether that went to UI's distribution operations, its transmission operations, or a non-tier D rate mechanism. So I think the direct and succinct answer to your question is that approximately $2.5 million figure is reflected as a component of cell E28 on schedule WPC 3.18, page 2. In other words, it is a component of the 29.3.
Understood. Thank you. So we'll next move to RRU 365, attachment 1.
We are there.
There's a line item, I believe referred to as other financial, there's other financial expenses identified as mark to market for retirement programs. So the authority would like to know what service is being rendered.
And I think we described this to some extent in our response on page 4. These expenses represent the financial expense related to changes in mark-to-market for employees within the ASC retirement programs. So the service that's been rendered to customers is they benefit from the provision of shared services to UI, and this is an expense that the shared service organization incurs in the process of providing those services.
Okay, so to be clear, so it's an outside vendor expense related to retirement programs?
So this is related to the pension expense for those ASC employees. And so what happens with pension expense is that you have to do an accounting adjustment and mark it to market every year. And so this is the mark to market adjustment for it. It's not, it's an accounting expense item that's done by accounting actuaries. They calculate it, they provide it to us, we record it. It's not like necessarily a vendor expense that we're paying somebody in essence, but it's your accounting entry to true up the value of the pension expense that you need to record, if that makes sense.
Oh, okay, so it's actuaries outside of the company that provide this service where they render the calculation, and then that calculation is reflected in this.
Yeah, so the actuaries outside of the company do the calculation and we do review it, right? So we'll ask questions and challenge it, and then we'll record based on it.
Okay, so presumably that the actual outside vendor expense itself would be reflected elsewhere in the C schedules.
Yeah, subject to check, that vendor is PwC, so it would be wherever PwC falls in that.
Okay, understood.
And I think we were chatting about that yesterday in the comp and benefits panel. We were talking about the vendor used for pension.
Okay, and that's usually a contracted service with PwC?
Yes, that's a contracted service with
Okay,
PwC.
and you're contracted with them through the rate year?
Yes,
Okay.
we are contracted with them through the right year.
Okay, I'm gonna switch gears to ADJ 006, attachment 1.
And I apologize, should have mentioned it earlier. There was recently an updated contract in place that was not in place for the test year, but is in place right now and will be in place for the upcoming rate year. We can provide you a late file exhibit and provide that contract to you.
Yeah, I think just pricing,
Sure.
the pricing terms
Yep.
would be appropriate.
Yep. So late file 47.
Yes, so that's Price Waterhouse Cooper contract for the rate here. It's specifically pricing terms that.
Yep.
Thank you. Confirming that is late file exhibit 47.
Thank you, Chair. So I'll reset. We're on ADJ 006 attachment 1.
We are there.
Okay, line 7. It describes a employment discrimination claim brought against Avangrid in Madrid court. So my question is, how does this lawsuit relate to UI's operations or the provision of electric service in its service territory?
One moment.
We'd like to take late file 48 for that one.
Okay.
Attorney Riley, if you could restate late file exhibit 48, please.
So I'm referring to ADJ 006 attachment 1, line 7. It's a defense of a lawsuit brought against Avangrid Inc. in Madrid social court for employment discrimination. And my question is, how does this lawsuit relate to UI's operations or the provision of electric service in its service territory? Thank you, Chair. So what is the process, sticking to line 7, what is the process or method of allocating legal expense such as the one described here? So is there a review of the matter to determine whether or how it's allocated?
I can speak in general to legal expenses. So we've, on the record, and I'd have to look up which reference it is, but we've filed our allocations policy that shows the cost causation factors for what any costs coming through AMC, ASC, and how they get allocated. So the types of expenses that do get allocated, as well as whatever the cost causation factors is, how they were determined, and then what that underlying calculation is. We've also filed all of those. So they have different drivers. So it might be the Massachusetts formula, it might be the number of people in the buildings, it might be the number of tickets that are received for a department. Whatever those drivers are, that's what drives how these different various items get allocated. So all of these allocations should fall under one of those items as outlined in that cost allocation manual.
Okay, so
And just the
Mr. Hurwitz.
record reference for that is Exhibit UI RRP 7 and legal services are specifically discussed on page 25.
Okay, so to your knowledge, is there a provision in that cost allocation manual specific to legal expenses in foreign jurisdictions?
There's coordination with external firms.
Okay. So under the allocation manual, it's conceivable that foreign discrimination actions brought in Madrid are allocated to Connecticut ratepayers.
Yes.
Okay.
And just to clarify, not necessarily all legal costs get allocated down. We do hold some of the costs at the AMC level. So for example, like merger and acquisition related legal costs, and I know we filed data responses outlining what does not get allocated down. But if it was in legal matter related to any of the items that do not get allocated down, that get held at the corporate levels, then they would not get allocated to the test year in the rate year.
Okay, but employment discrimination actions fall outside of that allocation.
There were no employment discrimination actions that were included in that listing for the test year and the rate year.
It doesn't ADJ 006.
There were none that were held at AMC ASC.
Okay, so all were allocated ultimately to the company and other affiliates.
In the test year, correct.
Okay. Are there, I believe ADJ 006 connects back to RU 241 attachment 1, tab 6. Are there other, is it conceivable that there's other line items throughout attachment 1 in which legal expenses related to actions in Madrid court are allocated to ratepayers?
I apologize. RRU 241?
Attachment 1, correct.
Your question, can you repeat your question again?
So this interrogatory, I think, was targeted at RU let's reset. ADJ 006 targets RU 241 attachment 1 tab 6 specifically. There are multiple tabs within that attachment 1. Is it conceivable that elsewhere in other tabs, legal expense related to employment discrimination actions or other actions brought in Madrid civil court are included?
There are very, very small legal fees in 2 other tabs within the schedule that we'd have to go back and check. We can include that in late file 48 if there's anything else related to discriminatory actions. I just don't know off the top of my head what's in those legal fees in those other 2 tabs.
Yeah, and specifically, I'm looking not just for employment discrimination actions, just any actions brought in Madrid civil court or any other foreign jurisdictions.
Sure.
And I'm actually going to refine it further and say non-Connecticut jurisdictions.
Okay, yep, non-Connecticut jurisdiction.
So we're refining, I'm sorry, I lost track of the late file number, but we're refining the request to through RRU 241, attachment 1. The company is going to review that attachment and identify where else there are legal expenses allocated related to any foreign or other jurisdictions outside of Connecticut.
Thank you. So that's just a refinement to leave Exhibit 48.
That's correct. Does the cost allocation manual address, does that also encompass Iberdrola allocations as well? Okay.
Yeah, there's, that's also been included on the record.
So let me be clear too as well. So this was a UIL action that we've been discussing, brought in civil court. According to the Iberdrola cost allocation manual, similarly, are there civil actions brought in foreign or neighboring jurisdictions besides Connecticut that are allocated from Iberdrola to the company?
If there were, they would be on that data response that we were just going through.
Okay, so it would flow. So when we're looking at that attachment, it's flowing not just from UIL, but from Iberdrola all the way
Exactly,
down.
all the way
Okay,
down.
it would be that,
Yeah.
the waterfall that
Yeah.
we're describing.
Our
Okay.
allocations are a waterfall, so they start Iberdrola, they go to AMC, AMC picks up Iberdrola, picks up all AMC, waterfalls down to ASC. They pick up all of everything that came from AMC, which includes Iberdrola, and picks up all ASC and then comes down. So you have the full picture in that data request.
Okay, so to summarize, it's conceivable that civil action, legal fees for civil actions, employment discrimination or otherwise would flow from Iberdrola in foreign jurisdictions to UI.
Yes.
Okay, thank you. Similarly, somewhat related, we were talking about legal judgments and settlements before. Same concept there. Is it conceivable that judgments or settlements in foreign jurisdictions or in states outside of Connecticut would be allocated from Iberdrola and other entities to the company?
That would have been included within the data response that I read out earlier on when we read out all of the settlements that were paid.
Okay. Not to keep expanding our LFE request, but let's expand that again to also add legal judgments or settlements allocated.
To clarify, you're just looking at us to take the previous data response that I had quoted and then including the settlements and just say which territory those settlements were related to?
So I believe our earlier request was asking specifically to look into the attachment 1 tab. And I had asked to identify legal expenses, inferring that it would be legal expenses that were incurred and flowed down. I'm expanding the request to include legal judgments or settlements.
So just to clarify, you're talking about UI attachment 1, line 7 for ADJ 006, and you want us to add another column that includes the legal judgments or settlement amounts for those cases?
Yeah, it's specifically, I lost my tab here, apologies. 241 attachment 1 specifically. So a comprehensive
Okay.
analysis throughout the tabs, not just tab 6.
241, okay.
Correct. One moment, please. Okay, EDJ, I actually think we're on the same for div fountain. No, apologies, ADG 6. And that, there's an attachment. Attachment 1 of ADJ 6.
We're there.
There's a line item here for Latham Watkins for specialized legal advice. And the notes indicate that they handle issues related to proposed legislation. So my question is, does Latham Watkins interact with legislators on behalf of the company? And/or does it advocate for or against legislation on behalf of the company?
I'm not sure offhand, but I'll note that our narrative response to ADJ6 describes that we intend to remove the costs reflected on this line item in our updated cost of service in this proceeding.
So we'll just back up from it. So there were Latham Watkins expenses removed from the rate year.
Not in our initial filing, but
Okay.
we do intend to remove the costs denoted on the line that you referenced in our case update.
Okay, thank you. I think that was the disconnect. Thank you. And then the line item also discusses financial disclosures as well. Is that related to items such as SEC reporting requirements and any other sort of regulatory requirements, reporting requirements?
It does relate to SEC, but again, as Mr. Hertz just noted, we are taking it out in the next update.
Okay, thank you. I'll move on in the descriptor in the notes. Compliance, is that related to Connecticut matters, or what sort of compliance are we talking about? Federal, state related jurisdictions?
You're still referencing line 8, right? That we're taking out.
Latham Watkins, correct. There's a note providing a brief descriptor.
My apologies. Could you please repeat the question?
Sure. So that line item to level set, we're on ADJ 006, attachment 1. There's a line item for Latham Watkins, AGR, specialized legal advice. And there's notes providing a description of the services rendered. And it, amongst other things, says issues related to proposed legislation, financial disclosures, compliance, ethics that arise in the normal course of business. So I'm asking about the compliance component. What is it? State regulatory matters, federal requirements? What does that encompass?
Again, we're not sure sitting here, but we intend to remove the amounts allocated to UI associated with this line item in our case update.
Okay, so
Thank you, Mr. Hurwitz. Attorney, not Benor, who's the only one not here, Vaughn. When we get to late file exhibit 1 submission, could we request that the company provide like a cover page that lists the items that are being removed? Because I think we've had a couple and it will just.
Yes, I do believe we normally prepare either in the response or in the Excel file that we submit. I do believe we list out the adjustments and we will do so here.
Okay.
I see Mr. Hurwitz nodding. I see Mr. Hurwitz nodding, so yes, we will.
Thank you, I appreciate that.
We're contemplating an attachment that is similar to LFE attachment 1 from 231102, if that helps, which I think is
Good.
what you're describing.
Yes, thank you.
and based on our exchange on the notes here, is the entirety of that Latham Watkins allocation that's being removed?
That's our intention.
Okay, understood. Thank you. I'm going to move next to other revenues, and this is simply going to be a late file exhibit request to please provide the company's annual reconnection service fees for 2017, 2018, and 2024.
And after we clarify that late file, if needed, we're going to take our lunch break, and that is late file exhibit 49.
I think we understand that one.
Thank you. All right, then we are going to break for lunch. We will reconvene at 1:15. Attorney Vaughn.
Good afternoon, Chairman Gillette. Just a few administrative matters. Over the break, Ms. Palella was able to locate or confirm read-ins B and C, and also confirmed with me that read-in D is probably best converted into a late file, given the time that it's taking to pull together.
Okay.
And further, Ms. Van Luling has read-in Z. So I'll take that in that if you'd like to do the read-ins and then issue the late file, whatever you want to do,
Thank you. Let's start with the read-ins, please.
Okay, so read in B, the question was confirm where in the BFP re-enrollment process where an authority decision, motion, or ruling approved that a customer could fail a BFP and continue to re-enroll. In the October 12th, 2022 final decision of docket 220501, the authority provided direction in section 4B related to UI's BFP auto enrollment. And within that section, the authority provided direction related to how the auto enrollment should be communicated to customers, which including the information that a customer who has failed out can re-enroll in BFP again with a zero down payment and begin monthly payments that lead to substantial arrearage forgiveness.
Thank you.
And then read in C, where in an authority decision ruling or motion does it indicate that the customer could not enroll in the former MPP until SEEP was received? And just to clarify, the company did not wait until the SEEP payment was received to enroll customers in the former MPP. The company enrolled customers when notification was received from the community action agencies that the customer had applied and was eligible for SEEP benefits as per Section 30 of the Connecticut Regulation, Public Act 23-102.
Thank you.
Thank you, Ms. Palella. Ms. Van Luling, do you have read-in Z?
Read-in Z, KPMG has been confirmed of the auditors for 2025. We do not have agreed upon fees, nor do we have a signed engagement letter or a draft engagement letter.
Thank you. And then Attorney Vaughn, circling back to late file or read-in D to convert into late file 50, I believe we're at. I jotted down, provide clarification of new MPP design costs. Does that match your recollection?
Yeah, I wrote down similar to that. I wrote down our costs associated with MPP upgrades included in this rate case.
Thank you. So we'll mark that late file exhibit 50 and mark out read-in D. So I have 8 read-ins active. N, P, Q, U, V, X, Y, and AA.
Did we do O? Yeah, I will double check my list, but just doing it on the fly. I think that list did sound generally accurate to me.
I think O is 2024 pet care usage. For some reason, I think
Okay,
we
yeah, I think we
converted
did
that
that,
to a late file. Okay, thank you. Okay, any other administrative matters before we begin from any?
Not from the company.
All right, very good. Let's resume cross of this panel by authority staff, please.
Thank you, Chairman. We're going to start at RRU 104, attachment 1, page 3. Specifically Excel line 71, row D.
I got the attachment open, but could you repeat the line and page reference, please?
Absolutely. We're on page 3, line 71, column D.
I am there.
Okay, so that line item is described as pertaining to conservation and load management. So my question is, why is the project labeled as such included in the base distribution rate proposal?
One moment. I believe the company answered that question in response to RRU 274, and the explanation is similar to the other CLM line we discussed earlier this morning.
Okay, thank you. And then I'm moving up that spreadsheet to Excel rows 45, 46, and 43.
I see those.
Okay. Those are described as expenses related to third-party payment agent services. So my question was, are these expenses different than fee-free costs? And if so, how?
These are different from fee-free costs. I would need to confer with someone in the audience to get a little more detail on exactly what these relate to, but I'll note that this tab provides information regarding the company's test year pro forma expenses and its rate year expenses, and subject to check, actually just one moment. Yeah, you can see on page 3, Excel column G provides the test year pro forma numbers for these lines, but you can see on page 2 of the same attachment, there are comparable lines providing the unadjusted historical test year values, and you can see that there are no pro forma adjustments related to these lines. In other words, these are costs the company incurred in the test year in 2023. The fee-free program only began after the end of the historical test year, so they could not be the same.
That makes sense. Thank you. Is the company forecasting third-party payment agent expenses to increase in the rate year?
As shown here, we've calculated the rate year amount for this line item by taking the historical test year expense incurred by the company and escalating it by the general inflation factor.
Okay, thank you. So if costs are related to third-party payment agents are expected to increase, how does the company reconcile that with expected greater adoption of the fee-free program? Or is it as you described previously, are they unrelated?
I don't know that I see these as related. I think the fee-free program is a program the company implemented coming out of its last rate case, docket number 220808, to allow customers to, certain customers to pay their bills via credit card with no fee. And if I were the customer service expert, I could maybe describe that more precisely, but I think that's the general gist of the program. Whether or not customers incur a fee when paying their bills seems to me has limited bearing on whether they're going to pay their bills in the first instance. If certain customers aren't going to pay their bills, it seems to me that the company would still incur costs to chase that money, even if that customer had the option of paying their bill without incurring a fee for using a credit card. So I am struggling to see the link that you're drawing.
Yeah, understood. Thank you. One clarifying question on line 45, cell D. The descriptor there is UI third-party pay agent dash WU. That refers to Western Union?
I believe that is correct.
Thank you. And we're going to move on to RRU 394, attachment 1.
I am there.
Specifically Excel line 20, which I have as the company's line 13, column D.
I see that.
Okay. The company is reporting a $59,467 non-refunded balance to customers in August. I'm sorry, pardon me. Let me try that again. So the company reported a approximately $59,000 non-refunded balance to customers in August 31st, 2022. Is that correct?
I would clarify that a little bit. The company is reflecting a $59,468 regulatory liability
Okay,
as of August 31st, 2022.
thank you. And column E of this response, sorry, same line, shows a credit to customers of $112,848 approximately, correct?
Correct.
So I'm trying to understand why did the company credit the customers this amount in August 2022 when the non-refunded regulatory liability was only 59,000 approximately?
The mechanism this money is returned to customers, I understand, was established by PURA as a separate volumetrically based amount, and it will fluctuate based on the amount of usage based on that customers use. It's not like the company deliberately chose to refund $112,800 when there was a liability balance of $59,678 thousand. Rather, and you can see amounts that are roughly comparable to the $112,000 in all of the prior months. The company was refunding the amount based on the rate that was set, and there's a small residual balance because of volumetric variances. And accordingly, we made a proposal in our direct testimony in this case to reconcile it subject to check, I think, through the RDM, so that we aren't continuously chasing these balances.
Okay, understood. So the authority is going to request a late file here. So providing an exhibit that shows the billing determinants used to derive the $112,848 credited to customers in August 2022.
I understand.
Thank you.
Thank you. That's late file exhibit 51.
Turning next to rent and lease expense and transportation expense, or specifically RRU 180 and 345. And we might be able to get through this one without the specific references. I understood the company's response to be that it intends to update these rent and lease expense figures, as well as remove certain right-of-way figures. And I just wanted to make sure those are being captured in LFE 1. That's what the company is referring to, correct?
That's correct.
Okay. And that will, again, logically, that will result in a different rent and lease expense for the rate year?
In total, that's correct.
In total, okay.
There will be a number of lines on the the referenced schedule that are unaffected by this, but I agree that total will change.
We're going to move to residual O&M. Thank you. There was an exchange during the panel yesterday regarding transportation expense, and I was hoping perhaps the revenue requirements panel can help clarify. So the test year transportation And I should clarify the schedule here, was Schedule C 3.13 WP footnote 1 regarding a $214,000 adjustment made. And if you recall the conversation, it was trying to reconcile with ROU 346 attachment 1 that showed 212 vehicles, and it seemed to indicate that those were reached or were past their replacement dates during the test year. So what the authority was struggling with is the exact same number of aged vehicles in the test year, again, being reflected in the rate year adjustment and how it's not a redundant expense.
I still don't think it's a redundant expense, although I see why you would ask this. There were 212 vehicles in the test year and 212 vehicles in the rate year. But I think what you're missing is the vehicles are going to be older in the rate year than they were in the test year. Our argument here is that it's costs more to maintain older vehicles. And so we're saying as these vehicles continue to age, the cost associated with maintaining them will increase. So there was vehicle maintenance cost incurred by UI in the historical test year, I agree. But we're saying the costs UI will incur in the rate year will be more because our vehicles will be older at that point.
Okay, so that adjustment's reflecting, I think I'm following. Let me confer with my colleague, please. Thank you.
And my apologies, we may have an extra comment in response to that last question.
Yeah, Steve Cadwalader with authority staff. But please, if you have additional to add.
I'm sorry, Attorney Riley, in my comments yesterday, I had talked about the Weibull distribution, and as these vehicles age, they will fail at an exponential rate, right? So it's increasing over time, so that that testimony yesterday really kind of defined why we asked for that incremental amount for the fleet. The outcome of 220808 put us in a position where we haven't been able to replace the fleet at the pace we would like to. That is going to drive additional O&M expense. Thank you.
Just trying to understand the logic of the adjustment. It seemed like the adjustment was a comparison between an aged vehicle versus one that hadn't reached its replacement date yet. And that aged vehicle would be a certain amount more expensive to maintain than the one that hadn't reached its replacement date. And so if you took 212 aged vehicles and made that adjustment, you'd come up with the $214,000 that's being added to the test year. And if you have the same aged vehicles in the test year, it seems like that particular adjustment wouldn't necessarily capture the fact that they're older and somehow have a different replacement or cost to them. And I'd just like to understand that a little better.
So just to say back to you, your question to make sure I'm following. It sounds like there's some sort of document or note that we've left that has given the impression that we derived this adjustment by comparing the cost of a vehicle that is prior to the end of its expected useful life to one that is at the end of its useful life. And you're saying, if we were to have compared the cost of a vehicle that is at the end of its useful life to one that is significantly beyond the end of its useful life, that might be a more significant increase than we've proposed? Or
It seems like the adjustment was based on the fact that you have an aged vehicle relative to an unaged, one that hadn't reached its replacement date yet. And that was the basis for making the adjustment. But if you already have those aged vehicles in the test year, then having the same number of aged vehicles in the rate year doesn't make that particular adjustment make sense.
All start with one personal anecdote and then invite my colleague to add. I think what your question is missing is this isn't a binary yes or no type thing, right? There's not one cost for maintaining a vehicle that is before the end of its useful life as compared to one that is after. I've owned two cars in my life, one that was from 1993 and the other that was from 2013. And I know from personal experience, the cost of maintaining that 2013 vehicle is significantly less than the cost of maintaining that vehicle that was way older. So I don't think the fact that these vehicles hit the end of their useful life in the test year means, oh, we automatically incur all of these expenses. I think, as Mr. Eves described, it's an exponential relationship, whereas the vehicles continue to age, the cost of maintaining them will continue to increase. So I think your question sounded very binary to me, and I don't know that that's reality.
I would concur with Mr. Hurwitz's comments. The failure rate of an asset over its life is not a linear rate. It's an exponential rate as it ages. So what we're reflecting there is that as those vehicles from the test year 2023 go into 2025 and 26, the rate of failure and the rate of maintenance for those vehicles is going to be higher than it was in 2023. That's a fundamental fact of assets and how they age. And the outcome of 220808 put us in a position where we can't replace the fleet at the pace we need to, driving an increased O&M cost.
Yeah, I don't doubt that as vehicles get older, they become more costly to maintain. I'm just not sure how the $214,000 adjustment captures that. Because it seems to be based on the number of aged vehicles, and the number of aged vehicles hasn't changed. So I don't see how the 214 is related to the escalation of cost to vehicles over time.
Is there a particular document that's left you with that impression?
Yeah, if you could refer to footnote 1 of Schedule WPC 313, where it explains that $214,000 account is to the effect of having 212 vehicles in the rate year that are past their replacement date.
So fundamentally, Mr. Cadwallader, you're disagreeing with the concept that maintenance costs will increase as the vehicles age, as they go further and further beyond their useful life. You disagree. You think the maintenance cost is a flat line. And I think we would have a fundamental disagreement with that concept.
I'm not saying that. I'm just saying that the $214,000 adjustment is based on the number of aged vehicles. And if that's the basis for the $214,000, then just saying they're getting older doesn't make that adjustment make sense, because you have the same number of aged vehicles in the test year. There needs to be a different rationale for the $214,000 adjustment.
1 second.
In the preparation for this case, we came up with a conservative estimate for what we believed the increasing maintenance costs would be. As we go into 2025 and 26, we will see what the real outcome is there. But fundamentally, the inability to replace the fleet will lead to older vehicles, which will lead to higher O&M costs. And we try to reflect that in the revenue requirement for this case.
Thank you, Mr. Eves. I think we're just going to move on. Thank you. Let's move to OCC 736, attachment 1, please, regarding residual O&M. 736, attachment 1. and specifically company line 26, which is 33 in Excel.
Excel row 36. See that?
Thank you. Can you explain what the bad debt W/O dash automatic in parentheses is referring to?
One moment. That particular row represents sundry uncollectible expenses, and that is uncollectible expenses that relate to not residential, commercial, industrial type customers.
I'm sorry, can you, it's non-industrial or commercial customers?
Not ratepayers.
Not repairs, okay. So let me try to understand. So is it a cost that the company is expecting to incur in the rate year? It doesn't sound like that, but.
It's a normal recurring expense, so it could be for things like if someone hit one of our poles and they needed to reimburse us for it, and we've gone after them and they haven't paid us, and so it needs to get written off. But this is a normal recurring expense that you wouldn't expect the exact same items for the exact same dollar amounts to incur in the rate year, but you would expect that you're gonna have similar type expenses in the rate year.
Okay, so it's not, when you said go after some, it's not like a legal expense?
No, it's not a
Yeah.
legal expense. It's like sundry. It's like any type of receivables that we would get outside, such as if someone owed us for damages to property, if we were looking for an interconnection fee and they hadn't paid their interconnection fee. It's any of those types of items that are non-ratepayer normal bills that we have receivables for that they may not have paid, and therefore there's a bad debt expense for them.
Okay, so it's encapsulating unpaid, non-bill related expenses?
Non-customer.
Non-customer, yeah, okay. I think I'm following, thank you. Company line 10, which is Excel line 17, same interrogatory. Can the company explain the OH, it's OH dash presumably occupation extension services or OpEx line item?
Yeah, just one moment. Broadly, this represents the company's overhead occupancy pool. I'm recalling a data request response that we submitted towards the end of the discovery period. We're just struggling to pull it up, but I think there was a data request that provided or two maybe, that provided an overview of the pool process and what these types of costs constitute.
Okay.
I'm just searching for that. was RSR 285 that provides a broad description of the OpEx and CapEx pools, and this is a particular OpEx pool related to overheads,
Okay.
or related to occupancy, excuse me.
And so it's an outside contractor expense? Or I could refer to the.
Not necessarily. This will reflect a collection of costs that fit under the bucket of occupancy, and RSR 285 describes how the company uses work breakdown structures to pool like costs and allocate them according to pool specific rules.
Okay.
It's the general cost of the buildings and like the utilities for those buildings. So some will be external, some will be internal.
Okay, understood. Thank you. Next, we're gonna move to RRU 254, attachment 1 pertaining to meals.
Are there?
Can you explain the difference between union and non-union meals?
I can. Excel row 12 labeled union meals relates to an element of collectively bargained benefits to union employees. And I see Mr. Reeves approaching. I'm sure he's about to give a more artful explanation than I was about to.
Yeah, as part of our collective bargaining agreement, there is a provision when our employees work overtime for a meal allowance that is collected in that cost collector.
Yeah, thank you. And then non-union would be those not covered under the CBA.
That's correct.
Okay. What's the company's policy on non-union meals? Is there a prescribed policy?
One moment, I just need to consult with someone in the audience.
Yeah.
We can get a read-in for you on the meal policy that's on our website.
Okay, thank you.
Let's read in BB.
Sure. Is it a written policy that could be submitted as a late file for authority staff?
We need to check we can take it as a late file. Either we can copy and paste what's available and either put it in, or we can download the document and provide it to you. Late file is fine.
Okay. Yeah, we'll take it as a late file.
Okay.
Thank you.
Thank you. That will be late file exhibit 52.
And executives and board of director members are not included in the figure reported in 254 attachment 1, correct?
So, correct, with the disclaimer that certain individuals could be employees of the company and also serve on the board, and they may have non-board related expenses, meal expenses that are included within here.
How does the company delineate or track the difference?
It's how it's charged.
Okay.
So if it's board related, it shows up on the board, it would show up in the board schedules. But if it was non-board related, so if it was an individual on the board, non-board related, working overtime or traveling, they could have that also serve on the board. They would be charging their time to that code, which is not a board related code, and it would show up in here.
Okay, so the meal, it's, how do I phrase this? So it's not necessarily like a reimbursement for meals. They have, what's the?
It is,
dynamic?
this is a reimbursement for meals, yeah,
Okay.
whatever was spent on your actual meals.
Okay, so hypothetically, that employee would fill out a expense report
Yes.
and delineate whether they were serving as a board member or not when they
Exactly.
incurred the meal.
But we do have individuals that have two roles, an executive role and a board role. And so there's a chance that if they were serving as their executive role, like we were talking about before, when you were asking if there's external board members or internal, we do some internals. If they had an internal work-related expense, it could show up in here.
Okay, and there's like a clearly delineated area of a expense report where they can
Yes,
report that?
the board, all of the board fees are processed separately.
Okay, understood. We're going to move to bank fees, RRU supplement 1.
Sorry, Attorney Riley, which R are you?
179, please, supplement 1.
The attachment.
Yes.
I have that.
Okay. Are we able to, is the company able to describe the bank charges and bank commission fees that are paid that show up on that item?
Yes. The company, of course, has bank accounts and does banking transactions on a regular basis. These are the costs associated with broadly those. This is different from the credit and debit card fees that customers would pay reflected in the fee-free program on the customer service outside service schedule. This is cost for company banking
Okay.
type activities.
Thank you. So there's no relation between the banking fees and any like New York Stock Exchange related fees that were allocated to the company.
No, these are not fees associated with that
Okay.
type of thing. This is
All right.
maintaining checking accounts type stuff.
Yeah. So you're good. Thank you.
And processing transactions in those accounts.
Good. Thank you. Understood. I'm going to turn to procurement and local economic development related topics. Yes.
Just in anticipation of the subject matter, Chair Gillette will bring up Mr. Lavulo, and it may make more sense to just swear him in now. He is identified as one of the discovery witnesses.
Thank you, Mr. Lavolo. If you could raise your right hand for me, sir. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you.
And Mr. Lavulo, could you just state your name and title for the record?
Peter Lavulo, Senior Director of Networks Purchasing.
Okay. Thank you. So we're referencing UPA 37. And I see from the response that UI reports supplier diversity data at the operating level. But what efforts are underway to grow relationships with diverse Connecticut-based businesses?
We do have various efforts underway. In 2024, we did start to record metrics by each company, each individual operating company. We do engage in events that are hosted by local chambers and organizations. For example, we attend matchmaker sessions, part of the Greater New England Minority Development Council, Southern Connecticut Black Chamber of Commerce, We have outreach with our suppliers and discussions with our suppliers about what their capabilities are, what their challenges are. We do also have second-tier reporting through our prime contracts as well to underscore the importance of supplier diversity and second-tier spend. So we do make that part of our premier prime contracts as well.
Okay. Thank you. And have any like partnerships been formed based on those programs?
We have had some successes in terms of meeting suppliers that were able to add on to the bid list so that they have an equal opportunity to participate in winning the bid.
Have you had any successful bidders?
We have.
We have, okay. And you mentioned the 2024 metrics that were established. How, I guess broadly speaking, how is progress measured, especially for categories with low current participation?
So we do measure, in 2023, we had measured more at the avant-grid level. In 2024, we developed metrics so that we could measure further into each operating company to the level of suppliers that we do business with in Connecticut at the avant-grid level, suppliers that UI does business with at the avant-grid level based in Connecticut. Does that answer your question?
I think so. Thank you. I'm going to turn to energy efficiency and climate commitments, and this is referring to UPA 29.
I think maybe you can ask your question. We will have, yes, we will have Mr. Pereira, who sponsored this discovery response, available, I believe, tomorrow on the Capital panel, Dan. But we can, why don't we ask the question and see if we can, if this panel can.
Sure. So here, the company's reference investment grade energy audit, an investment grade energy audit at its properties. And the authority was looking for an answer on where that process stands.
He's here. He'd be the best suited to respond to that question. So we'll get him over here and he will answer that question for you.
Okay.
When Ms. Van Luling says he, just referring to Mr. Pereira, who sponsored the discovery request, was previously sworn in. I think we can bring him over and try to do that if he is.
Okay, great.
Is he physically in the room?
No, I mean,
Then
like,
don't, but he's gonna be here tomorrow.
Yes.
yes.
Okay, we can hold the question. I don't
Yeah.
want to drag him over.
Yeah,
for-
do that, yeah,
We can hold the question for tomorrow.
sure.
Thank you.
And we'll move on. Thank you. Just circling back to RRU 178, attachment 1, page 1.
You said 178, did you?
That's correct. Attachment 1, page 1.
Did you mean 179?
I don't know. 178.
Okay.
Thank you.
I am there.
Okay. So we just want to make sure the additional dockets listed in the spreadsheet, those are docketed proceedings the company received and paid invoices for the test year.
Sorry, could you just repeat the reference?
Yeah, absolutely.
Struggled with the mic the first day too.
Did you break it?
That's like my cue to get in the hook here from the microphone. So yes, the reference was from RRU attachment 1, page 1. And I believe that connected to a regulatory assessments attachment.
I was just seeking clarity because this attachment does provide information regarding expenses incurred by the company in the test year, but it also provides information about expenses outside of the test year.
Yeah.
Including expenses in 2024 and that predate the test year.
Oh, okay. Yeah. So there was I think there were a number of dockets listed there. So it was just making sure when those invoices were incurred and paid.
I see.
Yeah.
One moment.
Yep. Yeah.
Correct. These all relate to expenses incurred by the company in the test year. And by these all, I mean the lines labeled regulatory dockets pro forma deferred on C 3.21 WP numbered lines 9 through 13. As I mentioned earlier, there are additional lines here that relate to other periods, but those particular lines relate to the test year.
Yeah, thank you, Mr. Horowitz. I appreciate your response, and that concludes the authorities cross for the panel. So thank you for your time this afternoon.
Thank you. We will move to cross by the OCC, please.
Good afternoon. We're going to start with some cross from Mr. Albert Zablaski.
Good afternoon. Just to get, can you hear me okay? This mic is crazy. Could we please start with C schedules? And this is schedule 3.06, line, hold on, I want to say 9. Give me 1 second. Actually, 3.06 work paper. And this is, yep, line 9, legal. Do we have the total amount spent in 2024 yet?
It's available. We provided OCC 556, which provided the 24 amount for this entire schedule, professional services. I don't recall if we've broken out legal specifically in a response, but we did provide the total amount for this schedule for 2024.
Okay, just in case, is it possible to get a read-in for that, just so we have that?
I think so, yeah.
Okay, I think I will use BB since we very quickly So I will mark that as read in BB.
Thank you. Next up, could we please refer to response OCC 278? Okay. When did the company start making this subsidy?
I'm not sure. OCC 278 provides data dating back to 2019.
Okay. When did the company first request the subsidy in rates?
That I don't recall either, but I do know this was an issue in contention in docket number 130119, UI's 2013 rate case.
Thank you. The response states that the subsidy acts as a safeguard to prevent substantial loss for the vendor. Does the vendor only receive the subsidy if it is incurring a net loss?
Good afternoon. Good afternoon, Chuck Eves, Vice President Electric Ops for UI. Just wanted to give a brief context on the business implications of our cafeteria. It is used in storm events. So when we need to call in crews on weekends, holidays, that cafeteria is there to meet our needs. It also provides a very efficient means of getting meals for our employees. So rather than having to leave the building every day, we have the cafeteria there, and for them to operate and ensure that they can remain viable, it requires a subsidy. So there is a significant business value to having that, both in day-to-day efficiency for our staff, as well as having the ability to provide storm meals when they're not readily available through restaurants or other things on holidays.
Let me just follow up with, if the vendor is making a profit, any profit at all, does it still receive a subsidy?
We provided some information regarding the circumstances that led us to selecting this vendor in Exhibit UI Rebuttal 3. We would have to review the contract and the terms to determine the answer to your question. I don't know that offhand sitting here now.
Okay.
But in the RFP process, the vendors would not submit an offer without some sort of subsidy due to the volume levels they saw within our facility.
So no vendor was able to take this on without a subsidy. Is that what you're saying?
That's correct.
Could we ask for a read-in for that last question, or maybe a late file?
In between the time where I said that and right now, someone messaged me that the answer is yes. They are paid whether or not there's a profit or loss. However, I will emphasize what Mr. Reeves just said. We conducted a competitive solicitation and no vendor was willing to provide this service, this critical business service, absent a subsidy.
You?
I'm sorry, Attorney Wheel, does that answer your question?
It does. Thank you.
Okay, and so there is no true-up, so that the vendor only receives enough to prevent a loss, correct? Just as part of that contract?
That is the implication, yes.
Thank you. Please refer to the UI Rebuttal 1 Revenue Requirement Rebuttal. And this is top of page 43. or PDF 45? Okay.
Or I am there.
Okay, so there's an estimate of $1.14 million of savings derived from having an on-site cafeteria. Are the $1.14 million of savings reflected in the company's filing?
Implicitly, yes, they are.
So,
In other words, the costs we would have sought would have been significantly more had we not had this cafeteria subsidy.
okay, so it's captured in the test year?
That's correct.
Okay, thank you. Could you please turn to RRU 365 attachment 1? I want to follow up on some bureaucrats also. And if we could go to that first tab, I believe it's the first tab, the RRU 240 and 241 summary.
I am there.
Okay, thank you. So there's an annual bonus category. Is that effectively just incentive comp of UI's share to ASC and AMC?
I think you got the gist. I'm just gonna say that in my own words. This is incentive compensation that is allocated to UI from the service companies.
Thank you. And on a different tab, the Office of the CEO tab, does the company know what the 113,000 in legal fees is?
We have a late file request from before on the other legal fees. I'm just trying to find which one it is. I think it's late file request 48, where I mentioned that there was 2 other tabs of legal fees, and we needed to provide the detail for that. That will be in that late file request 48.
Appreciate it. Thank you. On that same tab, what does the strategic bonus dash LTIP stand for?
Can you refer me to the row that you're looking at?
Sure, 1 second. It's Excel row 13.
Oh. There are 2 Office of the CEO tabs. I just want to make sure I'm on the right one.
There's one with a little itty bitty
It just says
I in front of it.
Just, yeah,
just says Office of the CEO, nothing else. There's no number in front of it.
perfect. Thank you. That's the long-term incentive plan, but that was removed, pro forma out of the revenue requirement. But that is the long-term incentive program.
Okay, and the reason for its removal?
I believe we responded to that.
Oh.
We're not seeking to recover it.
Thank you. There's a legal services tab with the Roman numeral 6 in front of it, I think. Let's see. But
We're here.
okay, and this is Excel row 30. The element description states total cost of life I. Would that be like life insurance?
Mhm.
Okay. And is it appropriate for that to be under legal services? I'm just trying to.
It's the life insurance cost for the internal labor. This tab includes internal labor costs. So these are the legal services individuals and their associated benefits.
Thank you. All right. Can we please go to OCC 882? And this is just regarding shareholder litigation, just some follow-up. Company stated that it cannot predict the outcome of these matters.
I'm sorry, you said OCC 882?
Yes, 882.
The entirety of that response reads, as I see it, there is no rate year revenue impact pertaining to the shareholder litigation proceedings reflected in the company's response to OCC 347.
Okay. And then would you agree that the nature of shareholder litigation, especially alleging fiduciary breaches in a merger, can result in material financial outcomes?
I'm just gonna object to, I mean, the witness isn't a lawyer, so I don't know, if I think he read the response, and if you want to ask him a follow-up about it, that's okay, but he's not a lawyer.
Yeah, I'm sorry, would I agree to what?
Would you agree that the nature of shareholder litigation, especially alleging fiduciary breaches in a merger, can result in material financial outcomes? That is the question I asked.
And say that as stated in this response, there's not a rate year revenue impact related to that shareholder litigation. It's difficult for me to hypothesize about what may or may not happen in the future.
Okay, so has the company conducted any internal assessment or materiality analysis regarding the potential impact? Or no?
Yeah, I just, I know I'm sure Mr. Hurwitz will answer that to his knowledge. There's ongoing litigation here, so there may be attorney-client privilege implications about what's being requested. I'm not even aware of the answer, but I just wanted to make that clear on the record that we won't, that we do have attorney-client privilege there.
The nature of our question is just asking, are there going to be distribution revenue requirement impacts to the company's expectation in the future as a result of any open litigation, even beyond the rate year? To the company's knowledge.
I think it's tough for us to speak to what may or may not happen in future cases at this time.
Thank you.
Thank you. Can we turn to OCC 881, please? And this is regarding severance.
We're here.
Would you agree that severance by nature is an unrecurring and unpredictable expense?
No.
No.
Okay. Would you agree that severance pay is based on specific employment events?
I would agree that the severance pay is based on specific facts and circumstances that occur with employees in the company.
I'll take that. The company is applying a blanket labor escalation factor here, I think. Which I guess assumes that the severance pay will continue with general wage inflation.
Mhm.
Do I have that right?
You have that correct?
Okay. The company also stated that there is no revenue impact from the update in this response. Is that just due to the immateriality of this line item?
No, I think the error described here was in the number that we put in a prior data request response, not what was in the revenue requirement. So we were bringing the data request response to the revenue requirement. It wasn't that we needed to change the revenue requirement, if that makes sense.
Okay, thank you. Would you just generally agree that sort of including speculative items in the revenue requirement can lead ratepayers to cover costs that may not occur?
I would disagree that severance is speculative.
And to add to that, and as described here, the amount we're seeking is derived from the amount the company actually incurred in the historical test year, which is by no means speculative.
Thank you. Can we please turn to OCC 853? And this is regarding stock ownership.
We're here, the witness to this was the Comp and Benefits panel yesterday, but we'll take your question and give it our best shot.
Thank you. The company stated that no officers or and executives are required to hold Iberdrola or Avangrid stock. Was this also the case when Avangrid was publicly traded?
I'm fairly certain this is the case. I can get you a read-in for it. I would just need to check with the expert that sponsored it. They're not coming back.
Is it possible to get a read for that one?
Sorry. They're out.
I don't blame them. No, it's just.
They might return for late file hearings.
Sure, we'll mark that late file exhibit, I'm sorry, read in CC.
Thank you. Do you know if was the executive stock converted to Iberdrola stock at some point or during that? No?
It did not.
Okay, so did any? Oh, okay, I'll move on. Thank you. Can we go to OCC 752? This is remediation expense.
And just before we answer it, just that we do have this response was co-sponsored by the Environmental Remediation Panel, who will be here on Monday. So I think you can ask your question and we can try to see if we can address it, but.
Thank you. Would you agree that one of the fundamental principles of cost recovery is that costs are non-measurable, prudence is reviewed, and the recovery occurs after?
Just before Mr. Hurwitz answers as he thinks, just stating that the witnesses are not lawyers and that they can provide their, factual understanding of how that works.
Yeah, I don't know that I can agree to the costs are recovered after part. And as Attorney Vaughn helped me with, I think prudence, I understand, is a legal question. So, and I am not a lawyer.
Okay. So still the company is proposing to recover a portion of these costs and base rates. Is that correct?
We are.
Okay. Would you agree that the cost of possible overruns or delays will be borne by the ratepayer?
I would say this. The environmental panel can talk about the backstory of the Shore project and why we think this is an important initiative for the company and how the cost amounts reflected in their testimony are supported by engineering estimates. We felt that this was an important project. We have developed a good faith estimate of what it will cost, and we have proposed reflecting portion of that cost in the revenue requirement in this case, while continuing the deferral and reconciliation mechanism that already exists to ensure both customers and the company are kept whole for any variances. Environmental remediation is this project is likely to take a meaningful amount of time and depends to some extent on what we find as we begin the project. So we have made a proposal that we think would allow the company to begin this project based on the best information that we have now. And I think the environmental panel can talk more about why we think this is important to the company, why we think this would provide value to customers. But this is important thing that we would like to do. We have developed a cost estimate to support the cost of doing so and are seeking to recover a reasonable portion of that in this case so that we may go out and execute the work.
Thank you for that. Could we please refer to OCC 748? This is regarding the corporate service charges.
I am there.
And I guess also Schedule C, 318 work paper 1, I think is the corresponding schedule.
I am there.
Okay. So just for clarification, in 2023, this expense was lower than in 2022 and 2021, correct?
Correct.
Okay, and the company is proposing an increase, is that right?
That is right.
Okay. Company also stated that, quote, all else equal, the allocation of costs to CNG and SCG under the Massachusetts formula will decrease. And conversely, the allocation of costs to UI under the same formula will increase. In what scenario would these costs not increase for UI?
One scenario that may have allowed these costs to continue decreasing is if the outcome of the recently completed CNG and SCG rate cases, docket number 231102, were different. As we describe at the conclusion of this response, one of the reasons why we think these costs will increase in the future, even though it decreased in 2023 relative to 2021 and 2022, is the factors that drove that decrease we don't expect to continue. As described here, one of the reasons for that decrease is the company began recording an entry to move certain costs below the line as a result of SB 7. That's something we did, and we're not going to continue recording new entries to do that in the future. That's a change that we've made and will continue into the future, but that's not going to continue to cause a continual decline into the future. Second, another factor that drove a decline in 2023 relative to the prior years is changes in the allocation factors, UI getting a smaller slice of the overall pie. However, as described in this response, that pie is sliced in Connecticut based on the Massachusetts formula. The Massachusetts formula considers revenue and plant, and for both of those items, CNG and SCG's numbers are going to go down because of the outcome of docket number 231102. As a result, the portion to UI will increase. We've also proposed discrete, known and measurable adjustments for things that we anticipate changing in the future. For example, we know that we are going to continue paying our employees wage increases, causing the costs of shared services to increase. We have specific pro forma adjustments for things like security costs that we would contend are known and measurable. So we think while there was a decline in 2023 relative to 2021 and 2022, the factors that drove that decline, we do not expect to continue into the rate year.
Thank you. So if the total shared service cost, the pool of it, I guess, if you would, right, or your allocation, right? If the total wasn't also decreased, for example, it's possible that the UI's allocation was still the same or not increase just because CNGs and SCGs went down.
I think one important data point in that regard is Schedule C 3.18 WP page 3. I know we've talked a lot about pages 1 and 2, but page 3 provides costs at the ASC level for each of the last 5 years, well, 2019 to 2023 rather, and it shows that those costs, which is analogous to the pie metaphorically, have increased pretty significantly over this 5-year period, from 215 million in 2019 to over 326 million in 2023. So pie's growing. It's just about the size of the slice that gets sent to UI. And we've described the reasons why we think that share will change the way I just discussed into the future.
Thank you for that. Go to OCC 713, and this is regarding student loan repayment expenses.
We are there, but I'll again note this was sponsored by someone on the comp and benefits panel who is not here, but give us a try and we'll do our best.
Thank you. Can the company confirm it's requesting ratepayer money to cover student loan repayment for its employees, regardless of whether their degree is related to work they perform?
Subpart B of this response describes, and I'm just going to read this verbatim. This is not like the tuition reimbursement program where people need to take courses that are directly related to an employee's job function. Instead, this benefit recognizes and attempts to help alleviate the mental and financial stress for the reasons noted above, regardless of what the degree is for. The company believes that it is common for employees to have college degrees that may not be directly related to their current job duties, as many people switch their careers after obtaining their degree when they find a passion in an unrelated field from their college studies. Overall, the dynamic nature of today's job market, the evolving career paths of multi-generational workforce contribute to this common occurrence.
That sounds like a yes. Thank you. And could you confirm if this program also covers student loan repayments if the degree is unfinished or abandoned?
And again, I don't know if this response was sponsored by you, Mr. Hurwitz. I believe it was, that we had those witnesses here for the compensation and benefits panel. And so if, you have additional questions that require an additional level of detail, it may be best to take a late file that Mr. Williamson and Mr. Visconti can help put together, as they were the probably witnesses on that.
I'll offer that the response to subpart D appears to be a direct response to your question. I won't read that aloud, but it's here.
Thank you. Appreciate it. OCC 711. Vacancy factor and overtime, 711.
I am there.
Okay. 1 second. You're faster than me. You've stated here that vacancy factor is not used in the calculation of overtime. And do you agree that vacancy factor assumes a level of unfilled positions within the company generally?
I think the gist of what you said is directionally accurate, but the vacancy rate doesn't assume anything. The vacancy rate is a calculation. And we've provided that calculation in a data request response on the record. However, the concept of your question, I think I could agree with. We have applied a vacancy rate in our proposed revenue requirement and also included open positions in active recruitment in recognition of the fact that at any given moment in time, the company will have open positions.
Would you then agree that there's a link between an increase in overtime and unfilled positions?
No, as Ms. Van Luling described via read-in and Mr. Eves described in testimony some number of days ago, the reasons for overtime are varied. They can be trouble, they can be minor storm costs, they can be major storm costs, they can be any number of things, and it's not directly tied to the number of people employed by UI.
And I believe, as I mentioned in read-in N, approximately 85% of our overtime or UID's overtime is related to unplanned instances.
Mm-hmm. Thank you. OCC 669 then. Please, 669. This is property tax, I believe.
Are there? We may just need one moment to rearrange our support people. One sec. Actually, why don't you ask the question and we'll.
Yes, it should be pretty straightforward. The company states that real estate is subject to a 5-year reevaluation cycle and that it further checks for a flux or delta of 10% to determine if further action is needed. As far as I'm assuming internal controls here, just reviewing the bills you get. Based on what's stated here, however, if the tax bill somehow, right, hypothetically, for each town was off by 9% for almost half a decade, you wouldn't be able to catch it, I guess is what I'm trying to say, based on that response. Would you like to elaborate?
Yeah, let me confer for one moment.
Thanks.
I'm gonna give this a try, and depending on if you have follow-up questions, I may need to call on my colleague. The company analyzes, as described in response to OCC 669, all real and personal property assessments annually. The 10% threshold is more of a guideline. So I think if the scenario that you described happened, if everything just so happened to be 9.99%, my understanding is not the company would say, oh, well, it's not 10%, so we're good. I think 10% is a threshold or guideline, but the company analyzes all of its assessments.
Thank you. And I'm hoping, I know you're hoping this is the last time anybody's gonna ask about this, but OCC 750, and this is regarding pet care. I realize there's a pet LFE at this point. Funny.
We are there, and again, this was sponsored by someone on the comp and benefits panel, but ask the question and we'll try our best.
A money question, hopefully. So I've heard several times, I guess, at this point that there's I guess no additional cost to pet care, right? And while I guess there's no breakout of pet care and it's like associated cost, isn't it essentially part of a bundled service? What I'm trying to get at is that there's probably an imputed cost to pet care as part of that bundled service.
So this was sponsored by Mr. Williamson, and I am not Mr. Williamson, nor was I involved in these negotiations. However, I understand your conceptual point. I think my problem with it would be that if we were able to procure one collection of services at a cost of X, and then procure that same collection of services plus one service at that same cost of X, I don't know that I would agree there is an imputed cost for that service.
Thank you. OCC 779, and this is just regarding the EV employee incentive.
And just to say this again, this response was sponsored by a witness on the compensation benefits panel and was adopted and discussed yesterday. So this panel can do their best, but
And I appreciate it every single time. There, in the provided attachment, there's an allocator of 81.6%, I guess. I'll check that. 779.
I see that.
Could you just, for myself, I guess, can you explain that one for me? And why? I guess is there just for the first GL account?
So the reason there is an allocator for Excel row 6, but not Excel row 7, from a like wonky accounting SAP nerd perspective is Excel column B, the business area. 1480, we refer to it as a common business area. Common means not specific to distribution or transmission. 1310 is a distribution specific business area. As a practical matter, the allocation of cost depends on FERC accounts, but these business areas are an indicator of the types of expense and whether they are distribution specific. There's a separate set of business areas for transmission that are not here because they're not transmission costs in the case, and then business areas for common, and 1480 is one of those.
Thank you. And would you say this benefit is necessary to provision of utility service?
This benefit is necessary in attracting top talent and given what UI's goals are in being a leading sustainable energy company. And so this benefit aligns with the goals of the organization as a whole.
Thank you. I've got another one that I hope you could answer for me. And this is the 712, and it's regarding volunteer time. But it does have a dollar sign next to it. My eyes. OCC 7112. The company stated, quote, except as described in response to subpart B, the company did not pay employees to perform volunteer activities during the test year, end quote. But doesn't part B state that employees received full pay while volunteering in company organized events?
Yeah, I think that's why subpart A says except as described in response to subpart B, unless I'm missing your question.
So in company events, the employees were in fact paid for volunteering, correct?
Let me,
If I turn that backwards, I guess.
let me take a step back because I know this was an item in OCC's rebuttal testimony and in OCC's revenue requirement testimony, and we responded in our rebuttal testimony. Broadly, UI is not seeking to recover the cost of the time its employees spend volunteering. The vast majority of employee volunteer time happens outside of working hours, on the weekends, late at night, early in the morning. And I see Mr. Cologne approached, and he may have more to add, but the vast majority of the volunteering performed by the company's employees occurs outside of working hours and is not compensated. However, there are a limited sliver of community engagement type activities that do occur during working hours. For example, spending times with kids at school. And in those instances, the company's employees do continue receiving their pay. And we are seeking to recover the reasonable and necessary costs of fielding a fully qualified workforce. So for a extremely small sliver of the overall volunteering that occurred in the historical test year, there are amounts reflected in our revenue requirement. However, subject to check, I think the amount was approximately $19,000 as described in response to RRU 286.
Thank you. Okay, I think that's it for me. Turning it over to Tom.
Good afternoon. Oh,
I'm so sorry, Attorney Wheel. I'm just thinking before you get into the groove, do we want, let's take our afternoon break and we'll resume at 3:00. Attorney Vaughn?
Yes. Thank you. I believe during the break, Ms. Hagan was able to locate the information requested for read in Y.
Very good.
All right, the read-in Y was whether the matters on line 13 of RRU 222 supplement attachment 1 were resolved in 2023. And the answer is yes, they were. The second part of that question was, did the court enter default judgment in each of those cases? In UI versus Kazran, technically the court approved a motion for default against the plaintiff. It was granted. And then in UI versus Romeo Simeone, a stipulated judgment was agreed to as the defendant appeared. So that was between UI and the defendant.
Thank you. Okay, very good. Then Attorney Wheel, please.
Good afternoon. My name's Tom Wheel, the Office of Consumer Counsel. My first question is a follow-up from Mr. Sobolewski's questions about the cafeteria expense. I thought I heard that the cafeteria operates to provide storm meals. Did I hear that correctly?
You did.
Okay. Is the cafeteria open like after hours during storm time? Oh, I see Mr. Eves approaching.
Rather than answering this next one, I'll let Mr. Reeves.
The cafeteria staff, Chuck Eves, Vice President Electric Ops, UI, the cafeteria staff will respond to a storm for us 24/7, 365.
Okay. And that includes like holidays, if there's a storm on a holiday? Okay.
I'm sorry, what was the answer? It was not.
Yes, I'm sorry. I nodded. I apologize.
Thank you.
Thank you. That was of course, Mr. Reeves is welcome to sit where he is, but that was my last question about the cafeteria and storm costs. I had a follow-up about the colloquy between Mr. Zablowski, who I think I might have just called Mr. Sobolewski, but I meant to call Mr. Zablowski. About severance. How was the rate year expense for severance calculated?
It's the test year incurred plus the wage inflation factor.
What is the wage inflation factor?
I mean, like the 10.9% reflected on one of the pages of C 3.18.
Okay. Is the logic behind that if the same number of employees get severance pay, that the severance pay would be 10.9% higher?
In effect, yes.
Okay. And does the company expect to pay severance pay to the same number of employees in the rate year as the test year?
The company expects to pay severance pay. We have data requests showing the severance pay that's been paid over, I believe, the last 5 years. I might be off on a year for that. And that data shows that UID does in fact pay severance pay. And so we would expect, and our best baseline is the amount that was incurred in 2023 plus the inflation factor for the severance pay. So the severance pay is usually tied to your salary, and therefore expecting salaries to go up, severance pay would increase with the general wage inflator.
And for the record, that data request response Ms. Van Luling just referenced, I believe, is our supplemental response to OCC 346, and that indicates that the amount of severance incurred by UI allocated to UI in 2023 was materially less than the severance expense allocated to UI in 2021, 2022, and 2024. In 2021, the amount of severance allocated to UI per that response is $369,355. In 2022, it was $298,142, and in 2024, it was $329,819. However, we based our rate year request on the test year level of expense, as we have most other expenses in this case, meaning the level of rate year expense that we are seeking is significantly less than the company's actual experience in those 3 recent calendar years.
Thank you. And looking at that response, 346, that supplemental that's filed on March 18th, 2025. Is that what you're looking at?
That's correct.
Does that, the first portion of that response shows severance pay at the UI level. So is that the severance pay for United Illuminating Company employees?
That's correct.
Okay. And the second is that for allocated severance, is that right?
That's correct. And the second, referring to the second collection of bullets in that response, that's correct.
Okay. So in the test year, there was $0 paid to United Illuminating employees for severance?
Correct. And we are accordingly not seeking rate year amounts for that type of business expense.
Okay. Thank you. Do you know, is it true that the aggregate severance pay in a given year is driven by the number of people who are leaving the company?
Not necessarily.
How is that?
It depends on what that severance pay could be. So it would be the individual times or the individual, whatever the severance amount is. So if it's a higher executive leaving the company, that could cost more in essence than maybe 5 or 6 lower paid individuals receiving severance pay. So it's not necessarily driven by the number of leavers, more driven, I would say, based on the total salary or total ending package of the people leaving.
Understood. But the severance pay for a given year will be higher if 2 people leave than if 1 person leaves. Is that correct?
Not necessarily. So if one person leaves with an employment agreement, I'm making this up, that says that their severance pay would be $30,000. And then there's another employment agreement in which the severance pay is $1,500. That would be $3,000 versus the $30,000. So it's not dependent on the number of individuals leaving.
I understand that. I guess my question more precisely is like in 2022, as of June, 1 person had left the company and received severance pay. If a second person after that person left the company and also received severance pay, the total number would be higher than it would be if only the first person had left. Is that
Yes,
correct?
that would be correct.
Okay. Do you have, is there anything in the record showing how many separations correspond to this severance pay amount in each of these years?
1 second. We're looking at OCC 854 UI Attachment 1, which does provide the positions and the company of the executive positions which severance was paid and allocated to UI.
I'm sorry, Ms. Van Leeuwen, can you say that reference one more time for me?
Sure,
please?
OCC 854 UI Attachment 1.
Thank you.
Oh, I see. I had pulled that up also, and that's a redacted exhibit, is that correct?
It is a redacted exhibit.
Okay. And just so I'm sure, I know we have access to the unredacted one, and I won't ask you to speak to what's behind it, but does this show the number of positions per year?
Of the executives, yes, it has the number of positions for the 2 years that are in question, for the 2 years that was asked in this data response.
Thank you. And that is just for 23 and 24, which was what was asked for in that data response, right?
Correct.
But is there anything showing that same, going back to OCC 346, the supplement that goes back to, that's 2019 through 2024. Is there anything that could show just the number of employees that match to those severance expenses provided in OCC 346?
Not that I recall.
Could we ask for that as a late file or a read-in?
Yep. A late file might be easier. We maybe need to redact some of the information.
Okay. And again, I'm just looking for the number of positions. We don't even need the titles. So like if in 2019 that the allocated $83,099 was because of 2 people, that's all
That's
we're
all you
looking
need.
for.
Okay. Yeah, we may need a late file just because it's going back to 2019. If you just wanted 2022, I could do a read-in, but if we could do late file, that would be.
Sure.
Okay, so late file exhibit 53 is provide the number of positions per year dating back to 2019 for the data in OCC 346.
Yes. It's the supplement to, I mean, it's the supplemental version of 346. I'm not sure whether the previous version had the same dates, but
Thank you.
thank you. I had a question about OCC 566, attachment 1.
And your reference to attachment 1, that's supplement attachment 1.
Not sure what I'm looking at is not a supplement. It's
Did I miss your 566?
566.
Apologies. That I have.
Okay. So this is a breakdown of the miscellaneous other electric revenues that are reflected in scheduled work paper 301, 3.01. Is that correct?
That is correct.
Okay. So I'm sorry to make you open multiple spreadsheets, but C.301 work paper has a rate year revenue. I'll back up a little. So these are revenues, these are offsets to the revenue requirement.
That's correct.
So the rate year offset is $350,000.
For this particular line item, that is correct.
Okay. But the 566 that we were just looking at as of September 2024, that's showing like $803,000, correct?
I see that.
So would that be updated in the late file 1 as a known and measurable expense? I mean, known and measurable adjustment to the test year?
Thank you for the question, Attorney Wheel. No, the company does not intend to update this element of its proposed revenue requirement for 2024 experience. The company's various revenues and costs will fluctuate year over year for a wide variety of reasons, and it would be inappropriate in our view to pick and choose things that are lower than the test year afterwards and omit things that are higher than the test year afterwards. And I think the response that I was starting to open up as I misheard your reference, OCC 556, attachment 1 will show a wide variety of cost increases in 2024. And so I think if we were to start layering in 2024 information, it would be inappropriate to cherry pick this one particular line. I will add, however, that this account flows through UI's revenue decoupling mechanism. So to the extent actual rate year revenues differ for this line item from the amount that we've reflected in our proposed revenue requirement, ratepayers will receive that benefit.
Thank you. I was also going to ask about the revenue decoupling mechanism relationship, but you just confirmed that that's the way the company would understand the way that that other revenues would work would be as a flow through the RDM. Is that correct?
That's correct. And for the clarity of the record, we are attempting to define the universe of other revenues in Schedule C 3.01. I know there's been some back and forth as to what counts as other revenue. In cases past, it's resulted in some litigation. We've tried to steer clear from diving into that in this case, but the items reflected on Schedule C 3.01 are what we would propose to reflect in the RDM as revenue, or as other revenue, excuse me.
Thank you. One last question about OCC 566. The other service deliveries, which is in Excel row 11, labeled 2. I noticed it flipped signs from 22, like it was revenue in 22 and 23, and then it was an expense in, revenue in 21 and 22, and then an expense in 23. I was just curious what that is and why that happened.
One moment. We are not sure, but would be happy to look into it.
Okay, could that be maybe a read-in?
Sure, this might be a small research project, so maybe better served as a late file.
Sure.
It's appropriate, or if that's okay.
Yes.
Late file exhibit 54, Attorney Wheel, if you could restate, please.
The reference is OCC 566 attachment 1. And the question is why other service deliveries converted from revenue to expense in 2023. Okay, I have some questions about cash working capital. So as it has been sort of discussed in the kind of dueling testimonies in this case, there are kind of two ways to think about cash working capital, right? Like there's is that correct that there are two possible proposals that are being discussed in this case for how to treat cash working capital?
I can start there, Attorney Wheel. So what we described was two broad approaches to cash working capital, one that focuses on O&M expenses and one that focuses more broadly on all the income statement cash impacts.
Thank you. And which of those is the proposal in the rate year?
We are proposing the latter, which looks at all of the income statement approaches. That's consistent with what Pura has found in the past about what fairness requires in terms of looking at each individual of the income statement and understanding that whether it's for accounting purposes a cash or a non-cash expense, it still has real cash impacts in terms of when when service is provided and when the customer's cash is received by the company.
Thank you. I just wanted to ask some quick questions for the record about Schedule B for working paper, which shows the working capital breakdown. And my questions are just whether, in the company's view, different expenses are considered cash or non-cash. So the first one is uncollectibles on line 6. Would that be cash or non-cash?
So again, there's two different things going on here. And so I will describe first the generally accepted accounting principles guideline. And so from that perspective, uncollectible accounts is a non-cash expense. But in the broader income statement view of cash working capital, that approach understands that there's still a cash impact to the company between when service is provided and the, I think, 50 or so day lag between when cash is actually recovered from customers. So to your direct question, from a GAAP perspective, it's a non-cash expense.
Okay. And from the income statement method would view it as a cash expense.
It would be recognized to have cash impacts, is how I would put it.
Okay. And the next question is about interest expense on line 20, just with the same question.
Interest expense is, it's not an O&M expense, so it wouldn't fall under the O&M approach. It's paid out of operating income, which is viewed as being owed to the utility at the time that service is being provided. And so the actual cost of capital, which this is a portion of, it's not an O&M expense. Again, there are cash impacts, which the broader income statement approach recognizes.
Okay. On line 21 for customer deposits, would that be a cash or non-cash item?
Again, I'd have to think about whether it's a cash item for GAAP purposes. It certainly has cash impacts as we recognized in the broader method. Interest on customer deposits, I would differentiate though from operating income and interest expense, in that it is traditionally subsumed within the O&M or the O&M portion of the revenue requirement.
Okay. Two more. Net income dividend, would that be as on line 22, cash or non-cash?
So the next two items, just to group them together, are similar to interest expense in that they're paid out of operating income. From a cash working capital perspective, those three things go together, or those four things, sorry. So operating income, and then with potential offsets related to the actual payment of dividends or interest expense. But again, not an O&M item as would be captured in an O&M only approach.
What's the due date on net income?
Net income is earned as service is provided contemporaneously.
What's the due date on a dividend?
Again, the operating income from which that dividend is paid is earned as services provided. Dividends, not speaking specific to the company here, are generally paid quarterly in the utility industry.
Okay. Thank you. My next questions are about OCC 675 attachment 2, which are leases.
This was sponsored by Mr. Pereira, but like your colleague, Mr. Soblowski, we are happy to give it our best shot.
Thank you. Well, what would be the best panel for this? My questions are, the reason I'm asking this panel is because of the impact on the lease component of the revenue requirement, but
I can give him a try now, and if I need Mr. Pereira, he'll be here tomorrow.
Coming back tomorrow.
Again.
okay. I don't need to maybe walk through every example, but I noticed that on OCC 675 attachment 2, well, I guess I'll back up. These leases were provided as to the OCC as part of our audit. And then this discovery request asked for copies of the leases. Are all of these leases flowing one way or the other to the lease expense in the revenue requirement? Do you know?
That would be my expectation based on how this response is described, but I would need Mr. Pereira to confirm, fortunately.
Okay. And this may be a question for him, but I had a number of questions about OCC 675 attachment 2 because there are a number of leases in that attachment that seem very clear to me to be transmission related and only transmission related. So that's also why I asked this panel, is I wasn't sure if there was allocation going on or.
I can give you one tidbit that may help if you bear with me for a moment. The company's response to one further. You said your questions pertain to attachment 2?
Yes, 675 attachment 2. Like actually, if you open that response and just look at the very first page, and you can the bottom, like where it says the first whereas term in there, and I know we're looking at a very old legal document. The point is, and I won't ask you as a non-lawyer to interpret it, but it seems to clearly reference that the lease is for a substation terminal structure for the purpose of connecting 3 transmission lines. So sorry, go ahead.
I was fairly certain that we had noticed the same thing you're noticing now in a prior discovery response, and I just found it. It was RRU 180 and specifically subpart C, where I think we're acknowledging the thing that you're noticing. My educated guess, and I think someone is confirming that for me via chat, is that the leases provided in response to OCC 675 relate to what was in the company's initially filed revenue requirement. And to your point, we were taking some of these out because they relate to transmission, and that's described in the company's response to RRU 180. We identified the same phenomenon with respect to telecommunications contracts. I think attachment 2 relates to right-of-way. OCC 675 UI attachment 2 relates to right-of-way. OCC 678, OCC 675 UI attachment 3 relates to telecommunications, and similarly, our response to RRU 180 subpart B identified a similar correction.
Okay. Thank you.
And there was a prior, a follow-up request where we identified the amount that will be reflected in our case update for these line items after this correction. I can't find that off the top of my head, but I recall filing it.
Okay. Just one moment.
That last response I referenced was RRU 345. Subpart C specifically.
Did you say 345?
Yes, RRU 345, subpart C.
Thank you. Okay, so that would be part of the late file 1 filing?
That's right.
Okay, so if I have questions about matching up these exhibits to the adjustment on late file 1, we'll talk about that in the late file hearing.
I'm excited to have that discussion.
Okay, great. Could you refer to OCC 70, please?
The attachment or?
Both, I suppose, yeah.
I'm there.
So in this interrogatory, we asked the company to provide a version of the quarterly earnings reports, like those that are provided in response to OCC 69, that shows a breakdown of O&M costs that are kind of presented in the same way that the applicable O&M costs are presented in the applicable rate case decision. And this response explains that the company doesn't maintain that on a quarterly basis, but we appreciate making an attempt to give it a shot in OCC 70, attachment 1. I was just curious, I wanted to talk about whether it would be possible on a moving forward basis to itemize on a moving forward, to be able to, would it be possible to on a moving forward basis, report these quarterly earnings in that format?
We're working on some system approaches that would facilitate that, but we're a little ways away from that being possible in full transparency. In the near to medium term, it will be really difficult for us to provide that format on a quarterly basis and ensure that the results are accurate and consistent with our financial statements. And the reason for that gets back to my discussion with Pura staff earlier this morning about how the revenue requirement is developed. We begin with the income statement and balance sheet as they're maintained in the company's accounting system, SAP, it's system of record. And the information in there is of the type that I'll just pick a random attachment we discussed earlier today. It's of the type of the data presented in our SR 309 UI attachment 1. There's cost elements, which are general ledger accounts. There's order numbers, WBSs, and the process of preparing a revenue requirement involves filtering and sorting all of that data into the various revenue requirement schedules that we've presented here. And that is a intensive effort that would be difficult on a quarterly basis. But we are exploring the possibility of system changes to make that easier going forward.
Okay. And those system changes presumably would cost money, correct?
It's possible that we will seek recovery of those costs in a future rate case, but we are not seeking recovery of those costs now.
Thank you. Could you open OCC 876 attachment 2, please?
I am there.
So this is we're just discussing the quarterly filings the company makes. This is the quarterly filing for the 12 months ending December 31st, 2024.
That's correct.
I'm looking at tab 1B, cell F26, that shows the operation and maintenance expenses.
See that?
Okay. And the total there is 317 million. It's like $318 million, correct?
I see that.
Okay. So it's probably obvious. I have some questions about this. It's probably obvious where I'm getting at, but I'm hoping I can just walk through step by step to kind of get there. Subject to check was the portion of the revenue requirement authorized in 220808 that was imputed for O&M expenses about $151 million.
That sounds consistent with my recollection.
Okay. And subject to check was UI's requested total O&M for rate year 1 in that case, about $162 million.
I don't remember that number offhand, but I would take that subject to check.
Okay. And I guess this is a tough one to be like a double subject to check, but if that number, if the 162 million were filed within late file 1, would that have represented the company's ask as of the filing date of that exhibit?
Would have.
Okay. Thank you. And does it, and subject to check, was the filing date of that exhibit March 16th, 2023? Does that sound right?
That sounds close enough. I don't remember the date, but take that subject to check as well.
Okay. So if you open OCC 69, attachment 1, please. Page 285 of that PDF.
$285.
Yes.
I am there.
So would this have been the most recently filed quarterly report on March, in March of 2023? Sorry, March 16th specifically?
I do recall that we provided this on the record in docket number 220808.
Thank you. Yeah, I'm just trying to, all I'm getting at is would this have reflected the company's sort of most recently reported financial information as of the filing of late file 1 in that last rate case?
This would have reflected the most recently filed ROE report at that time. However, I'll maybe anticipate where the dots you're connecting here. This ROE report reflects not just what I will call true distribution, i.e. the distribution costs we seek to recover in rate cases such as these, but also certain rate mechanisms that are not transmission, i.e. this includes revenues and expenses related to the CLM mechanism, and two others that are eluding me at this particular. It reflects a couple of other rate mechanisms that are, I can't remember exactly, but this is not exactly comparable to the costs that we seek in base distribution rate cases. And so I know you're picking on the O&M expense line, but I think you would see similar variances in the revenue line. For example, the revenue requirement that was established in docket number 220808, subject to check, was approximately 385 million. However, in OCC 876 UI attachment 1, total electric operating revenues are 434 million. And that's not because we set rates that were different from what PURA approved, but because of the inclusion of those other rate mechanisms I just described. So it's causes both the revenues and the expenses to be not apples to apples to the figures you're just pointing me to.
Okay, thank you. And you did anticipate, like my next question was going to be if your most recently reported expenses, O&M was 223 million, why did you only ask for 162 million? But that explains that.
That's the reason.
Okay.
And it's a similar reason why we are seeking less than 318 million in this case in O&M expense.
Thank you. Could the company provide as a late file, like a breakdown of what else is in both the revenue and expense side of what flows into these quarterly reports?
Yes.
Attorney Veal, is there reference OCC 876 or are we back on?
It would be OCC 69, which is a OCC 69 attachment 1 shows several of these reports. So the late file would just be a narrative explanation of what revenues and expenses are reported on these reports generally.
Thank you. That's late file exhibit 55.
Mind if we take just 1 second to confer?
Sure.
And for what it's worth, Attorney Wheel, we file those ROE reports on a quarterly basis, as you are clearly aware, and as UI has done for quite a long time, I think dating back to at least the 1990s. We did not make a specific proposal in this case, but we would be amenable to changing the way that ROE report is calculated to reflect just base distribution. I described the challenges we would have with adjusting the itemization of O&M expense, but if OCC is interested in reports that are more directly comparable to the rate cases, we are amenable to making that adjustment in the future. We would presumably need some permission to do that. I don't know that we can do that on our own, and we would need to confer with counsel, and I'm not a lawyer, et cetera, but the company would be amenable to that change.
Thank you. Or maybe like OCC could brief a suggestion to the authority to order such a change, and then maybe that could be how it could happen.
I am not positioned to tell OCC what to do.
Thank you. The testimony, UIRRP1 generally discusses, well, would you agree that the testimony generally discusses the impact of the 220808 decision on the company's current earned ROE?
I would, yes.
Has the company performed an analysis to determine exactly which cost drivers exceed the level allowed in rates I mean, would you be able to point to our ROE is this low because this actual expense was this much higher than this authorized expense? I did see some broad explanations in the testimony, but I was just wondering if there was sort of a more precise analysis.
When you say more precise analysis, are you envisioning something like a waterfall chart with the authorized ROE on the left and the earned ROE on the right, and some bars that show the primary drivers that take you from A to B? Or are you thinking, because we have provided, as you alluded to, a variety of analyses, and I just want to make sure I understand what you mean by more precise analyses.
Yeah, I mean, I guess I'll frame this as like a series of conceptual questions. Would you agree that distribution rates, the notion is that what we're trying to do here is set the distribution rate that most closely reflects the company's actual appropriately incurred distribution expense in the future rate year?
I would.
Okay, so the analysis that we'd be interested in is essentially like what was wrong in what within the 220808 decision inaccurately reflected the expense, but with as much specificity as possible. Like I've referenced before, I see in the testimony that there are sort of general statements saying that this disallowance in the company's view was inappropriate and imposed difficulties for the company, but I haven't seen, and maybe I'm missing, like a dollar for dollar, this much was allowed in this line item, but we actually incurred this much, if that makes sense.
We've provided, I would say, all of the pieces of that analysis in various places. For example, our response to OCC 70 UI attachment 1, page 6 provides actual UI distribution expenses by I'll call C 3.0 category in the rate year from 220808 and compares that to the amounts approved by line item in that proceeding. But that schedule that I just referenced does that for all of the elements of O&M expense. There's a separate figure in the revenue requirement testimony showing how UI's actual net plan in the rate year in question in 220808 was subject to check a little more than $200 million higher than UI's actual net plan that year. And I think there was another figure whose number escapes me where we did something comparable for depreciation and property tax. But if it would be helpful to OCC, we would be happy to put something together that combines all of those fragments into the precise story that you're seeking.
That would be helpful if the company could do that.
No problem.
So could that be a late file exhibit?
So late file exhibit 56, provide an analysis comparing the 220808 authorized revenues to, Attorney Will, you want to take over?
Sure. I'll just 1 moment, Chairman. I think maybe I'm just going to pull up the 220808 decision because I think maybe we could just reference like the tables in there. I mean, I'll ask Mr. Hurwitz, would it be possible to show us like in the same format of the constituent tables of the revenue requirement, like what the expenses were. So for example, we've been talking so far about O&M. I don't know why I'm having so much trouble.
One moment, I might be able to make a proposal if that's amenable to you.
Sure.
I've pulled up the final decision in docket number 220808, and this is me anticipating what you might find helpful. So of course, please feel free to correct me if I have misdiagnosed, but I'm anticipating table 1, the pro forma summary of average rate base. Table 42 on page 111, the summary of O&M expenses by what I'll call C 3.0 category. And then table 80, the approved revenue requirement, which will include the non-rate based, non-O&M items comprising the revenue requirement. Is that the level of detail you're seeking?
Yes, I was looking at table 88 and I was going to ask if it could be presented like table 80, but including the kind of constituent tables that make up the pieces of table 80. But I think what you just described does that.
Yeah, as long as tables 1 and 42 are constituent tables in your view, I think we can do that.
Okay. So Chairman, maybe it would just be a reference to tables 1, 42, and 80 of the 220808 final decision.
Okay, so, and the request is to provide a crosswalk between the decision tables and what the company has spent.
The test year actuals.
I was with you right up until that.
Actually, the rate year actuals as the 220808 rate year actuals, which was September 1st, 2024 through 2023 through September through.
Yeah, subject to check. I think it ended September 1, 24.
Okay. I have a couple more questions about some sort of more conceptual rate making questions, but pertaining to the revenue requirement. If you're ready. Okay. So I think, Mr. Hurwitz, you may have been alluding to this a minute ago and you may have been discussing with Pura staff, but when the company sits down to calculate a rate year revenue requirement, it's framed as a deficiency, right? Like what's being calculated as a revenue deficiency.
I think the ultimate output of a revenue requirement that everyone focuses on is certainly the revenue deficiency, but I think a revenue requirement is just that. It's a calculation of the revenue the company requires in the rate year. So we start by calculating, or we start by deriving actuals in the unadjusted historical test year through the process I described with Pura staff earlier, identifying pro forma adjustments. And I think our revenue requirement testimony in this case describes the 6 or 7 categories of pro forma adjustments that we seek and how we approach those. And after going through that methodological process, we arrive at a rate year revenue requirement, i.e. the amount of revenue the company requires to have a reasonable opportunity of earning a fair rate of return on and of capital invested for the public use in the rate year. Then that result is compared to expected revenues at current rates in the rate year, and the difference between those things is revenue deficiency. If all of that means the answer to your question is yes or no, I'm not sure, but that's the process that we take.
Thank you. I think that if I just asked when the company calculates its rate request, that's framed as a deficiency, correct? Because I think the nature of your question is that the revenue requirement is the total revenue needed. The deficiency is the difference between the current revenue and total revenue needed, correct?
I think if you look at, page 1, maybe it's line 2 of our testimony, we state the deficiency.
Yes. Yeah, I was gonna ask about, there are, is it fair to say that there are kind of two revenue deficiency calculations that are considered? And I'll explain in a second. The first being what I think of as a test year deficiency, which would be the difference between the test year costs and actual revenues. And I think that's what's shown on page 27 of your testimony.
That sounds right. Just give me one moment. Correct. The calculation begins on page 26, but that is right. That figure calculates what you've described.
So that showed about a $40 million deficiency between.
Correct.
Okay. And then as I was alluding to before, there's a sort of a second concept, which I think of as the rate year deficiency, which is what we were talking about before, the difference between revenues and expected rate year costs. Is that correct?
Correct.
Okay. And that would.
And just for clarity, figure 7 in our direct testimony, the figure on pages 26 and 27 you just referenced, is not something that we calculate when developing a revenue requirement. In every case, this table provides information regarding our costs in 2021, 2022, 2023, and then compares those things by line item to the output of 220808. This figure was important to us because this deficiency, this test year deficiency, is the basis for our interim rate request. This is not always part of a revenue requirement calculation. The base rate increase that we are seeking outside of that interim rate request is the rate year $105 million deficiency we discussed.
Thank you. That was going to be my next question. Is that what I called the rate year deficiency? That's the $100 million total request in this case, right?
Correct.
So does that mean conceptually that there's an expected incremental total cost of service increase of $65 million between actual test year costs and expected rate year costs?
Conceptually.
Okay. And I've heard the company provide calculations, including, I think, during some of the direct testimony earlier in this case, of the level of net income that would be necessary to earn the authorized rate of return at current rates. I can re-ask.
My apologies, Attorney Wheel. I just want to clarify one point on your prior question. This isn't a hypothetical increase of $65 million for stuff that may or may not happen. To a large extent, we've seen actual cost increases in 2024 that have aligned with what we're seeking, and to a significant degree, the company has continued investing in its system, driving its plant balances higher, and it's issued debt and all manner of things that have driven this number higher. This is the test year deficiency to get to the cost to the ROE approved in 220808 based on unadjusted test year figures. But there are a wide variety of things. For example, test year depreciation expense will reflect depreciation accrued during the year. So an investment installed in December will have just 1 month of depreciation, whereas it's known and measurable that depreciation will be annualized into the future because it will keep depreciating until the end of its useful life. So I just want to make clear that it's not $65 million coming out of thin air. This is real cost that the company is incurring and is appropriately seeking to recover in this case. So my apologies. I just wanted to clarify that, and I missed your next question.
Thanks. Well, I can back up a little. So was that a response to I think I framed my question as an expected incremental total cost. Was that clarification? Was there Like,
That's-
was that a soft objection to the word expected?
That's a fair characterization.
Okay, so, but the 65 million ultimately is the difference between the calculated deficiency that would have, the calculated, what we call the test year deficiency before, and what the revenue requirement to get through the end of the requested rate year would be, right?
I would agree that the difference between 105 and 40 is 65.
Okay. So we've also, in this case and in some of the, I think it was provided in some of the presentations regarding this case, heard a calculation of the necessary revenue for the company to be earning its authorized ROE. And the most recent number I heard was 54.8 million. Is that correct?
That's correct. It's in the testimony of the regulatory policy panel of the 54.8 is the net income in order to achieve the 8.63 return on equity at a 50% equity ratio.
Okay. I guess I'm curious conceptually, I recognize that's a more recent calculation than the end of the test year, right? Like that's as of the last quarter. Is that when that calculation was made?
That's right.
But would the calculation, the $40 million deficiency we just talked about before, that's on page 27 of your testimony, would that have been the same equivalent calculation as of the end of the test year? Meaning, would the company have also calculated and needed $40 million more net income in order to achieve its authorized ROE at that time?
My apologies, Attorney Wheel. Could you please repeat the question?
Sure. My question was, would the same analysis of calculating the necessary incremental net income to earn the authorized rate of return, that calculation at the end of the test year, would that have been a $40 million? Would it have been the same as what we just called the test year deficiency?
So we're looking at two different things. The 54.8 is a net income number. And then the $40 million that we were looking in the revenue requirement testimony is a revenue requirement number. So I don't know if you recall, but on the very first day when I read in the testimony, I read in that we would have needed $54.8 million in order to achieve the 8.63 allowed ROE. And we actually had $27 million. That variance is 27.8 million net income. When you gross that up, that gets you to 38.4 million, which would be the revenue requirement that you would need, which is aligned with the $40 million using the same comparative numbers. So it's a little apples to oranges in these two numbers that you're trying to get to. So you need to convert them to the same thing to see the true variance, if that makes sense.
I understand. I get it now. So there's a dumber way of saying that by saying the 54.8 million is saying this is what our net income would need to be. It's not saying that we need 54.8 incremental dollars in order to earn our authorized rate of return.
Exactly. And we did have net income. We had net income of $27 million for the period ended in 2024. So we have partially to get to that 54.8. We're not going from 0 to 54.8.
Okay. And the delta between those two, between your earned net income and the 54.8 was what? You said it a second ago.
It was 27.8 million, and that's net income. So you need to gross that up for a revenue requirement.
Okay. So if you gross that up, and by gross up for the revenue requirement, you mean you'd need to add the tax
Add
implications.
the taxes and, yeah.
So if you, that 27.8 grossed up, would that be conceptually equivalent to what we called like the test year? If you did it at the time of the
Yeah,
test year?
the only other apples to oranges here, and they're very similar numbers and the results were pretty similar, is one's using the test year of 2023. And on the first day when I read in, I was using the year-end results as of December 31st, 2024. So technically they were two different periods, but again, the net income was similar for those two periods, so.
Okay, thank you. I had a bunch of questions about this, but I think I can wrap it up into just like one or two conceptual questions. If I compared the level of revenue the company requested in 220808 versus the calculation that we were just talking about, and found essentially that what the company was requesting was a lot more than what the company is now saying it would need in order to earn its authorized rate of return, would the difference between those two numbers be because the company requested a higher rate of return in the?
It would be twofold. One, the company requested a higher rate of return, and then two, what's also critical is we requested plant and future plant. And so due to the decision of 220808, we've cut significantly the plant. And so therefore the rate-based dollars are in the actuals are significantly less than what the request had been.
Okay. But the calculation of that, of the 58.8, the incremental 27.8 that we're talking about, that is inclusive of like the depreciation and authorized return on the plant, on the existing plant that was disallowed in 220808.
The calculation of the 54.8 is based on what our actual rate base number is as of December 31st, 2024, which is approximately $200 million higher than the allowed. But it is not based on what we had asked for. So it's based on what our actual rate base is.
Gotcha.
And one other point to consider, similar to the point Ms. Van Ludling just made about plant, there will be a similar concept for O&M expense. Off the top of my head, the company made some O&M expense proposals in that case that Pura did not approve, such as raising the storm reserve accrual threshold from 2 million to 3, or certain incremental FTEs, or certain changes to the UPZ program. And so when those were not approved, we then did not do those things and did not incur the costs.
Okay, that was going to be one of my last questions, I think, was that kind of concept that like that the testimony generally, if you would agree, discusses like the decisions the companies had to make about the costs it incurs in order to align with revenues. In other words, what you were just referencing, there are some costs that the company requested in the last rate case that weren't allowed and that the company therefore has not incurred. Is that correct?
That is absolutely correct, yeah.
Okay, but then are there also costs, this is kind of getting at the late file that I was asking about before, that the company is incurring, but at a lower level than, at a higher level than what revenue is supporting?
That is absolutely correct as well. And depreciation is a good example of that particular example, and the ones that Mr. Hurwitz gave before of the ones that we made the decision to not go forth with because they were not allowed.
And there are also practical limits on what the company can do. The level of net plant established in the revenue requirement approved in docket number 220808 was consistent with the level of net plant UI had, I want to say in 2020 or 2021. So to comport UI's operations with that level of net plant, we would have to not only not invest at the level we proposed, we would have to not invest at all for several years for depreciation to work us down. So UI's was already cooked because there were hundreds of millions of dollars of plant additions in service, used and useful to customers that were not reflected in rates. And if they're already there, built, what action can we realistically take to mitigate that?
Okay. The late file that we just discussed, is that going to include kind of both classifications that I just talked about before, meaning is that going to capture the expenses that the company requested in 220808 were denied and did not incur, or chose not to incur?
One moment.
I think that will be hard for us to show to the penny, but what we could do is provide the attachment for the late file we discussed earlier, and then in the text of that late file response, provide a narrative discussion of the steps the company took of the ilk we were just discussing, the constraining plant, not hiring incremental FTEs that were not approved and things of that nature, and lay out to the best of our ability the financial impact of those things. I think it will be difficult to do the categorization you're seeking like to the penny, because that would require a significant degree of judgment, but what I offered.
Yes, that would be helpful. I don't think we probably need to change the late file description for that. Okay. And my last question pertains to, I think the company was ordered in 220808 to present these quarterly reports that I've been talking about to exclude the costs that are disallowed by the rate decision. As a backup question, is the company incurring some costs that were disallowed? I guess that's question number one.
Yes, one example of those costs are incentive compensation expenses. My understanding is UI's incentive comp was fully disallowed in docket number 220808, but UI has continued to offer its employees incentive compensation because UI feels that it's an important part of fielding a qualified and capable workforce.
Okay, thank you. And the actual earned return that's been referenced in your testimony and in other testimonies here, is that the earned return calculated excluding those costs or including those costs?
We present the calculation both ways in our ROE reports that are used for earnings sharing purposes. For example, in OCC 876 UI attachment 2, tab 1D, you can see Excel rows 17 through 24 provide the calculation without excluding disallowed expenses. Then Excel rows 27 through 42 provide the expenses that we see as in question. And then Excel row 50 through Excel row 56 provide the ROE calculation adjusted to exclude those items.
Thank you.
We've done the calculation both ways in our ROE reports that are used for ESM purposes.
Thank you.
Just to clarify, the ones that I referenced on the first day, the 3.55, that was based on the actual equity percentage, and it did include, so we did not take out the disallowed costs, and that was the 3.55. If you excluded as in those disallowed costs, it would have been 4.05%. So it's not a huge difference.
Thank you. And the 54.8 million figure, was that calculated including or excluding those disallowed costs?
That's the net income figure that would needed to be achieved to get to the 8.63. So in theory, that's like the net income you need to get to. But the comparison point of the $27 million did not have those costs excluded from it.
Okay. Understood.
So the 27, so when you take the 54.8, subtract the 27, if we took those costs out, I think the costs were 3.8 million. You would take the 27 up by about $3 million.
Gotcha.
Bring the variance down. It doesn't, I mean, it changes, but it doesn't bring it anywhere close to the 8.63.
Okay. Well, I mean, if it's not that much money, then maybe it's just kidding. I think that was my last question, and Consumer Counsel Coleman has some questions.
All right, home stretch. Claire Coleman, Office of Consumer Counsel. I just had a few questions about the company's corporate structure and related corporate service costs that were prompted by the authorities' questions earlier and the exchange there, I think in relation to Schedule C3. But I don't think you need to reference that yet. I just wanted to first make sure I understood the corporate organizational structure as referenced all of the different corporate entities in those exhibits. So the UI company, UI is here today as an operating company.
that's seeking a rate increase for its electric distribution services, right?
Correct.
And UI as an entity also engages in transmission work. So we see in those reference exhibits as a first sort of layer of allocation that the majority of the operating costs are split between transmission and distribution. Fair?
That is absolutely correct. The way you're describing it is, from what I would say, is you're going bottom up. So you're starting at the bottom and you're going up.
Yes.
Okay, just so we're following.
Yeah, we're
Yes.
gonna work our way up.
Yep.
So then that's UI, the company, and then there's UIL, the holdings, which is the parent company of UI, the company, SCG, CNG, and
Berkshire.
Gas, right? Okay. And then continuing up the chain, I guess who owns the shares of UI, the operating company?
So the next level up is Avangrid Service Company. We'll also refer to that as Networks. That is the company that is the whole co that oversees all of the regulated utilities.
Okay. And what's the distinction between Avangrid Service Company and Avangrid Management Company?
So Avangrid Management Company is the next level up, and Avangrid Management Company oversees Avangrid Service Company, as well as the power component of Avangrid.
And when you say Avangrid, is that then Avangrid Inc.? The next
Yeah, that's
level?
the top. Yeah, so said another way, if I went top down, it starts with Avangrid Management Company. They're overseeing Avangrid Service Company as well as Avangrid Power. Then if you drop to Avangrid Service Company, they're overseeing all the networks entities, including UIL. Then you drop down to UIL, they oversee UI, SEG, CNG, Berkshire. Then you drop down again because UI has distribution and the transmission component.
Okay, right. And then, so above AMC is Avangrid Inc.
Yeah, that's the whole AMC is essentially there's no charges from Avangrid Inc. They all come from Avangrid Management Company.
Okay, so stated another way, AMC and ASC are both subsidiaries of Avangrid Inc.?
Yeah, they're technically subsidiaries, but there's no charges that come from Avangrid Inc. All the charges are at like Avangrid Management Company. So we don't have employees of Avangrid Inc. You're an employee of an operating company, Avangrid Service Company, Avangrid Management Company, or Avangrid Power. There's no, Avangrid Inc. doesn't have employees, if that makes sense.
And that's why, so then you wouldn't see allocations from Avangrid Inc. to UI, just from AMC or ASC to?
Yeah, it's super confusing, and I'm glad you're asking. It's a waterfall. So Avangrid Management Company charges down, and so they're charging to Avangrid Service Company, or they're charging to Avangrid Power. If they charge to Avangrid Service Company is like a pool, and they say, okay, I got all the charges that came down from AMC, plus whatever ASC, the Avangrid Service Company charges are. So I'm an Avangrid Service Company employee. So my charges flow in at that point and get captured with the Avangrid Management Company charges. Then they're pooled together and they go down to the operating companies. So, and UIL Holdings. So at that point, UIL Holdings now captures everything coming from Avangrid Service Company, which includes the charges from AMC. But when you're looking at the charges, AMC can charge ASC, ASC can charge UIL Holdco can charge UI, but you don't see AMC directly charging in the flow through, directly charging UI unless it's outside, like unless it's an actual direct charge, but you won't see allocations from AMC to UI because of the way it all flows down.
Okay. So if we take that waterfall up one more notch with, starting at Iberdrola, then Iberdrola flows to AMC,
Yes.
then ASC, then UI.
ASC, then UIL, and then UI.
UIL, okay, and then UI, all right.
I think there is in the corporate services manual, there's a little chart. On,
Thanks. I was trying to look for that, actually.
yeah, on page 43 of 50 in the revenue requirements panel, Jacob will read it, exhibit 7 has the visual depiction of the waterfall and all of the, so that you can see it a little bit better.
Okay, great. We'll take a look at that. So what prompted all these questions was because I think if I heard correctly before in your conversation with Attorney Riley, when you guys were discussing RRU 365, I think UI attachment 1, and the allocations, there was a reference that there are now costs allocated from Iberdrola to UI. Is that right?
It's going through the waterfall here. So it's starting, they started at Iberdrola, went to AMC, AMC went to ASC, ASC went to UIL, UIL went to UI, UI went to the distribution component. So the cost started at the top, and I'm making these numbers up, but let's say the cost started at $100,000. 75,000 would have gone to AMC, sorry. If they started from Iberdrola at say like $1 million and 100,000 went to Avangrid Management Company, let's say 75,000 then would have gone down to Avangrid Services Company. Then from there, probably only like $14,000 would have gone to UIL Holding Company. Then from there, $10,000 would have gone to UI. And then from there, $7,000 would have gone to UID. I did not use the right allocation factors in that, but just to give you an example of, and so what they were asking about was, I see $7,000 at UID, explain this to me.
That's helpful, thank you. And I think in, if I followed RRP Exhibit 20, which was referenced as the source in RU 365, which showed that $685,807 were allocated from UI, or from Iberdrola to UI. You want to check that, or?
Yeah. That's the direct charge, it is not the allocation. I know
Okay.
we did give a work paper, and maybe if I talk long enough, they'll find it, that has the Iberdrola charges, but I may need to do it as a read-in.
Okay, we can keep talking, and if it comes through.
Okay, we may have to do a read-in on that, but we did give a work paper with the charges that go down.
Okay, so prior to the merger, were there any Iberdrola costs flowing through this waterfall that would hit UI?
Yeah, when you say merger, which merger are you?
Yeah, the privatization of Avangrid,
The December 31st, 2024 privatization, yes, there were charges coming from Iberdrola since Iberdrola acquired it's technically, the December 31st, 2024 event was not a merger, so I misspoke. It was the purchase of the remaining shares. However, the Iberdrola charges have been coming through since the initial acquisition since the formation of Avangrid.
so there's no changes as a result of the purchase of those
The remaining shares, correct.
on the flow, the allocation flow. To
Yes, exactly. There's no change in the cost allocation manual in how they flow down. There's normal changes that occur every year on the calculations. So each charge has a cost causative relationship behind it that has a driver for how it's charged. So it may be the mass formula, and the mass formula depends on everybody's revenue, plant, and everyone's payroll expenses. And those will naturally change as those numbers change. They don't fluctuate a lot, but they change mildly. Or another cost causative factor could be the number of people that are sitting in each building, right? So depending on the number of employees that you have in each building could drive that. So each year we go in and update those factors, and that will change the amounts that get allocated down, but that's part of the normal process and has nothing to do with the purchase of the incremental shares.
Okay, so in a unrelated but related interrogatory. It's OCC 264, which was sponsored by Ryan Shields, who's not on this panel.
He is here, though.
I don't know if you need him. You might be able to I think I'd like to reference it, but I think
Sure.
it's your confirmation as related to the allocation. So it says that it says that Iberdrola's acquisition, quote, did not result in any changes for the utilities or their customers. So I just wanted to confirm that that applies to this allocation flow.
Absolutely, that
and
that
the-
absolutely could.
And overall the revenue requirement.
Yep, yep. There's absolutely no changes. We have in various different data responses mentioned that we're going to be updating the next revenue requirement for the delisting, the revenue expenses that we will no longer incur because of the delisting, but that those are all decreases to the revenue
Yeah, I
requirement.
saw some of those on the
Mhm.
spreadsheet. Okay, I don't think I have any other questions on that. Do you, either of my colleagues?
I just have Tom Wheel again, just a couple of quick follow-ups. The charges, the Iberdrola related charges, so those were being allocated before, like when Iberdrola was just a shareholder?
Yes, when they were an 81.5% shareholder to Avangrid, they were allocating charges to Avangrid, which went through the exact same process that I just walked through, yes.
Okay. And are those the same, like, is the nature of those costs the same as like what's allocated from, for instance, AMC?
Yes, yeah, and we have, they're in the record, but the Iberdrola service agreement is between Iberdrola and Avangrid Management Company outlining each of the services that are provided, what those cost causative drivers are, how they're calculated, and the services that Avangrid Management Company is receiving.
Okay. So that includes like a portion, presumably a very small portion of like Iberdrola's CEO compensation?
One moment. No, the Iberdrola CEO compensation is not included.
Okay. And I'm sorry, you just said it, but what was the reference to where we could see the, like what's included and what the purpose of its inclusion was?
For Iberdrola or for?
For Iberdrola.
I did not say it. I need to look that up for you. I know it's in the record. We'll just read it into you.
Okay.
Okay, and that will actually be read in EE because I think read in DD was the work paper reference that Consumer Council asked for. So just clarify.
Okay. All right, that was OCC's last question for this panel. Thank you.
Very good, thank you. Attorney Nigro? EOE? No question. Attorney Wright? NECTA? Commissioner Karen? Thank you. I have just a few. A couple clarifying questions from me based on cross from earlier this afternoon. Just really quickly, when there was a conversation about severance pay, I thought I heard the response or the testimony to be that all contracts include a severance pay provision, but I thought maybe clarify.
No, not all contracts include a severance provision. Some contracts with executives and employees include severance provisions. It's all dependent on like the individual and the company and what was negotiated at the time of the hiring. So some contracts do, some contracts don't, as well as some employees may receive severance even if they did not have a contract because of the facts and circumstances for the employee leaving.
Thank you. Is there some subset that automatically does include like directors and above?
No, no.
Thank you. Just a general question. Is an executive being terminated considered to be an action by the board of directors?
I'm not clear if that's a legal question, but I think that Ms. Van Luling may be able to, provide what her factual understanding of that, but I'm not sure if we're talking a contract interpretation or something like that, or some sort of statutory interpretation. I just wanted to make it clear that Ms. Van Luling,
Sure.
Can I quickly discuss with our legal counsel 1 second?
Sure.
I know the appointment of new officers is in required action by the board. I'm not sure about the termination, so we're going to check and we can do read in FF for you on that.
Thank you, because I was just going to offer to rephrase and say maybe a cleaner way to ask was who makes the decision to terminate an executive? Is it the board? Like, is it a vote of the board? That's more precisely my question.
Sure, yeah, we'll get that for you.
Thank you. Okay. In a discussion with OCC specifically regarding the interrogatory response OCC 556, I believe, there is the use of the phrase other service deliveries. My question is if you can either, as we're sitting here, clarify what constitutes other service deliveries, or I think there was a late file exhibit, we could add that too.
While we were looking at that, we have determined it's a collection of various different billing activities, but we'll add it to the late file so we can further expand upon that.
Thank you so much. And I think it was late file 54, just for clarity. Okay. I apologize. I had one more question on severances. There was a discussion with OCC regarding, I believe, two data responses, OCC 346 and OCC 854. There may have been related interrogatories. My question is there somewhere where I could find across those responses or others if the severances that are delineated are the result of a merger or acquisition?
But I can add it. I'm 99% sure it's zero, but what we can do is we had I think a late file for the number of the severances in each period, and I can add in that if there were if any of them were related to a merger or acquisition.
Thank you so much. I'm just gonna find the late file exhibit number here.
It's LFA 53.
Is that 53 perhaps?
Yeah, I have 53, the number of people.
Okay, thank you. If you could just identify in that late file exhibit if any of those positions accruing severance are due to a merger or acquisition. Thank you. And I think my final question is, earlier there was a significant discussion with the authority staff regarding legal costs. And I know there were a number of referenced interrogatory responses. Is there, as well as a late file exhibit request today, is there a place that provides complete itemization of all legal costs to include attorney fees, litigation costs, settlements, judgments for litigation outside of Connecticut that are included in the test year or rate year in the company's application? And if not, is that something we could just add to that late file exhibit?
Yeah, there isn't, my interpretation of the late file exhibit would be that it included that, so we can absolutely include that.
Thank you. I appreciate that. I think that was back to late file exhibit 48.
Yep.
Okay, I believe that was my last question. Let me just double check here. Okay. Would the company like a moment to consider redirect?
Yeah, please, a couple minutes would be great.
Okay, thank you. We'll recess. Okay, if we can go back on the record, Attorney Vaughn, any redirect?
Yes, thank you. We have limited redirect. Mr. Hurwitz, earlier today, do you recall cross-examination from the OCC on RRU 365 Attachment 1, specifically with respect to an line item entitled Strategic Bonus LTIP?
I do. That particular line item relates to LTIP, which we've removed from the proposed revenue requirement via pro forma adjustment. However, just for clarification purposes, as my colleague, Ms. Van Luling, testified yesterday or maybe a couple days ago, the company does not pay bonuses. The presence of the word bonus in that Excel attachment is simply the SAP lingo automatically assigned to an account that is not a reflection of our business practice or how we think of the company. It's simply the name, written text name of a general ledger account in the company's system, but it is not intended to contradict or disagree with Ms. Van Luling's completely accurate characterization of how the company operates.
Thank you very much. Ms. Van Luling, earlier today, do you recall cross-examination on the company's volunteerism activities?
I do.
And can you explain why volunteering in the community is important to the company and community?
Thank you. So volunteering is important to the company and the community because it strengthens our relationship with local stakeholders that provide critical service in our communities. It also gives our employees the opportunity to engage directly with community members and stakeholders to gain critical perspectives and a better understanding of the issues community members are facing every day. They can then take this perspective back to their roles in the company. It helps us foster a culture of social responsibility within the company. It also provides much-needed support to under-resourced nonprofit organizations and contributes to the well-being of the community. We recently sponsored activities to help nonprofits with projects and activities that they don't have the time or the manpower to achieve on their own. To illustrate this, I'd like to read a message that we received from one of our nonprofit partners. The quote is, "Oh my gosh, it was truly fabulous. They made such a huge difference for us, beautifying our grounds, raking, putting together close to 290 candy bags, straightening the books in the library, organizing the kitchen closet, art and craft projects, playing games in the gym with the children, and serving as a guest speaker in our skilled trades program. I cannot thank you enough. Thank you so much. My heart is filled with so much gratitude." In addition, volunteerism also closely aligns with Pure's recent direction to UI's affiliate utilities to deepen its interaction with community leaders and residents of environmental justice communities to gain a better understanding of their specific needs and concerns, and to establish a model of corporate responsibility and community engagement within the state. Our volunteer activities during work hours help to achieve these important goals and outcomes.
Thank you, Ms. Van Luling. And is there anything additional regarding volunteering during work hours that you would like to address?
Well, Avangrid employees may engage in volunteer work during normal business hours. This is subject to a determination that the company's operational needs will not be affected, as well as manager support. In other words, employee volunteering neither negatively impacts the provision of service to customers nor comes with an additional cost. In addition, Avangrid employee volunteers also perform the majority of volunteer activities outside of business hours, approximately 85%.
Thank you very much. That is all our redirect, Chair Gillette. I think a few of us missed what read-in DD was, and so I just wanted to clarify what that was before we broke for the day.
Sure. The OCC, I think I wrote down that Consumer Counsel Coleman was looking for a reference to a work paper. But that is the extent of my notes, and I apologize, I don't see her.
Hi, Tom Wheel. Was that the last read-in?
No, it was the one in before. And just to clarify, we believe it was the reference to the work paper that had the total Iberdrola charges allocated to UID. But just wanted to clarify because I was turned around and looking behind me.
That's what it was, yes.
Okay.
Thank you.
Okay.
Thank you very much. That's all we have.
Okay, thank you. Very good. Is any other party or intervener have any administrative matters before we break for the day? If not, we will adjourn and reconvene tomorrow at 10 a.m. And we will begin with the OCC's panel, and I'll expect them to help me remember. I believe we're going to adopt Mr. Sobolewski's interrogatory at that time as well.
Well, I'll confirm Mr. Sobolewski's availability. It would be either then, or we also have a rate design witness who will be testifying later in the hearing.
Okay, thank you so much. All right, we'll see everyone in the morning.
Thank you.